Please pass on the memo. Last pass on the memos.
Yeah.
Whatever. Pass on.
My lord, pardon, my lord. Item 32 is the afternoon this matter and not more notice was issued. Each of the tribunals each of the files the government. My lord, this has been passed in 16/5/2024 and been released on 10/1/2020. Matters in the Pune, my lord, that is actually to IS officer's ego.
Should I discuss it now on the mentioning?
My lord,
Yes, wait, let it be called, madam. We'll hear
He's not
out
getting
stage.
salary.
Don't worry.
He's not getting salary for last 2 years.
Whatever, we will get it. Let us reach. We'll reach.
That's not reaching. That's why I'm praying that.
Oh, don't underestimate the pace of the court.
No, my lord.
Just wait, we can
But
reach.
because of the precarious condition, my lord.
Whatever, we'll consider.
The
Yes.
place admission next week.
Whatever, it is already there in the list.
My lord.
Wait.
Let's say we pardon to mention, it's a matter pertaining to the illegal migrants from Bangladesh. They are concentrating in the particular area and they are doing the illegal prawn cultivation and.
They will pass on the slip, sir, memo. We'll consider. Don't.
Press admission item number 1. Item 1.
Include the judgment.
The infant judgment is annexure 2.
Annexure any or annexure 2?
Annexure 2, man.
Annexure 2.
But the opposite party number 5 is the appellant before your lordship. He joined in service in 2007. In 2018, after summer vacation, the headmaster didn't allow
Him to join. Yes.
Thereafter, in October 2018, he sent the name in recognition form, the name of the respondent number 5. Thereafter, he approved this honorable court and honorable court directed to file appeal. In appeal, under annexure 1, the Lord Education Tribunal, after considering the entire records produced before him, came to the conclusion that the appointment of the opposite party respondent number 5 is a frivolous one, and the records are and the documents filed by the appellant are all genuine, and she directed the tribunal directed for reinstatement. In the writ, Honorable Single Judge has set aside that order. After serving 10 years,
Why?
my lord, your lordship can see that the impugned order paragraph 6
Yes.
at page 85. Having heard on counsel appearing for the parties and move the appeal case, alleging therein that he was from discharging duties as against the post of clerk, but in the memo of appeal, so available in the case of record, no specific date has been indicated, for which the opposite party number 5 was so prevented from discharging duty. My lord, tribunal in paragraph 11 in the order under annexure 1 has categorically held that he was prevented.
Although I have gone through the petition but it's a little bit more examination. Because state educational tribunal.
I find that there was no resolution which was produced before the courts or the traffic.
With great respect, my
We
lord.
want to hear of the matter. Tell us when you can get yourself
Next week.
because the pleadings are already complete.
Yes.
So
Also,
there's
sir.
no difficulty.
In hearing.
hearing.
But the private parties are there.
So you have to serve a notice upon them because he is.
For us,
The notice of the private.
First 5 years.
It's matter to appear immediately after the.
Yes.
Item number 2.
My lord, I have filed interim application.
Oh, what interim? You are out of job for a long time. Here, somebody, he opposite party number 5 here.
No. She was allowed in 2018.
Whatever, sir, she is working from 2018 to 2025. Yes. Yes. Can we disrupt now at this stage?
Your lordship kindly see for a moment at page 112.
Whatever, sir, interim order, we
Your
can't.
lordship,
Can't say
your
that,
lordship is
this
notice.
country have made that
Your lordship is notice. One set of process.
Yes.
Item 2.
My lord, I will serve extra copy to my learned friend for 1 to 2.
I do not know what is the concept here. Anyhow, whatever is there, you, sir.
Extra copies
I
of.
think if he is representing all the respondents or opposite party, one copy is sufficient for him.
Yes, 4 and 5 notices to.
I will take notice. 1, 2, 3. I will serve extra copy.
One, two, and 1, 2, 3, 1, 2, 3. This
What is this?
one set of
IAS notice.
The in charge my lord failed to rescue the girl. Your lordship sir, were pleased to my lord direct this superintendent of police Puri to monitor the case and to rescue the girl. But till date my lord no rescue.
Item number 3.
In this case, I have filed my power.
What is the accused order?
My lord.
And next one?
Yes, good morning.
Yes, sir.
My lord.
Was that you have the certificates that you
No,
belong to a particular
I have-
reserve category.
My certificate has been issued. In this case, what happened, my lord?
After these cases filed or before the case?
No, my lord. It has been issued before commencement of the rule, my lord.
Why did not, why you didn't submit those documents before?
Those documents are very much available before the committee, my lord.
If not there. the
No, my lord.
document
That is not
no.
because before the committee, they are saying that.
Show us the document from you.
No, my lord. It has not been filed by
Then
him.
why-
Your lordship, I am showing your lordship.
Sir, your claim is
From
that
there-
you belong to an ST category.
Yes, my lord.
They say, show us the certificate that you belong to
No,
ST.
my lord. What happened? My lord, that is not
Community in which
the.
you belong comes within that schedule.
My lord, I am within the schedule. That is not the case, my lord, actually.
Then
My lord, your lordship may see, this, an objection has been raised. I was in service.
says that
The
you have,
certificate has-
sir, the question is that you secured the service by offering your candidature as a reserve category candidate.
Yes, ma'am.
Later on, somebody raised objection
No,
that you
some-
don't
some-
belong to
some-
that category. So you have wrongly been put into that particular post.
My lord.
So now they have made an investigation.
My lord.
They want to
Investigation
prove
is-
that you belong to an ST category. You
invest-
could not produce a single document.
Investigation has not been done as per the judgment of the Honorable Apex Court in Madhuri Patil case, my lord.
What oral evidence you said that you should be given an
But it should
opportunity?
be-
What oral evidence you will give?
Our
Certificate?
my lord,
That's all.
it should be there should have been taken the oral evidence of the locality.
What for?
My lord, the culture and about the customs by that process because
Particular community or a
Yes.
class is included within the ST.
yes,
This is prepared
Yes.
both by the central
yes,
and by the state.
yes,
They prepare that which community or a class of a
yes, ma'am.
community would come within the purview of the ST.
Yes, ma'am.
If anybody wants to avail,
Yes.
then he must have a certificate from a competent authority.
But because
Because I belong to this category. Where is the certificate?
may I submit,
Yeah,
ma'am?
right.
Because certificate has not been issued
So,
since in land records it has been stated by caste Pana, not we. Your lordship may see the order of this honorable court, previous order of this honorable court.
You got converted.
No,
You got converted.
no, that is not within my knowledge also. It is we community.
you can't do it, sir. My own judgment is against you.
I have gone through the judgment also, your lordship judgment. Your lordship,
Where a lady who belongs to a unreserved category married to a person who belongs to a reserved category, claiming that I now belong to a reserved
no, man,
category
that is
not permissible.
that is not the case here also. Your lordship may see the
I'm
annexure.
saying, so conversion is
No, my lord.
impermissible.
There is a direction from the state government. This honorable court, my lord. This honorable court, your lordship may see the order of this honorable court in a previous case, my lord. Your lordship may annexure 7. Court shows
Or to have
Your lordship may-
allowed him to participate in the selection process.
no, it is not. It is
Without having a certificate.
and at that point of the rule is not there. Before rule that has been given to me.
In terms of the direct erosion inquiry, you also will find from page 45 inquiry report starts. 46 last paragraph, you will also make page 46. The part of the inquiry report, last paragraph of page 46. Verified the school admission register of Behera Gaon UP school and Tenpuri IB school, which indicate that Lochal had admitted in Behera Gaon UP school by additional so and
His father name was given as,
both the cases, his father
and his, the caste has been mentioned as father.
yes,
No, that is not.
Correct.
My dear lordship may see the
This document.
no, my lord.
uh,
Your
this
lordship may see
document
the-
traces his origin way back in 1966 or 70.
your lordship may the RTI application I have obtained through RTI. Your lordship may see for a moment.
What?
Page 72
RTI from whom?
from the headmaster of that school, my lord.
So what he says?
He said there is no such column related to the caste in the register also.
No, there is no column.
Nowhere.
No column.
Yes.
Something is written there.
No, nothing has been written.
What are they saying? Have you said that whether it register the caste or the
by way of
something
an
is
additional
reflected?
by way of an additional liability that has been filed before the learned single judge, my
The
lord.
problem with RTI is that they have to give us answer to a specific query. If the query is made in such a ambiguous manner, so definitely they give. They must have asked, is there any column where the caste
No,
is
my lord.
reflected? He will say there is no column. Then you take an advantage.
No, my lord. They have given the entire page 72, your lordship may see. No, 46, my lord.
70.
The report is not correct because nowhere it has been written I am a Pana caste, my lord. Because by taking the certificate from the then MLA, last portion. Certificate.
Where is the RTI query and where is the answer?
Man, that is the,
Where is the RTI query?
man, that is not with me. Your lord may put it after
Everything
petition.
is in here.
Man, no, my lord. It has been asked by the petitioner to supply the entire documents. What I gathered from the counsel from the petitioner, my
If
lord.
you have unscrupulously obtained the service without.
No, my lord. He has not obtained unscrupulous.
Yes, plus me.
And you are just the report without publishing things.
Yes, sir.
Without
Here,
publishing documents.
here the plea has been taken.
This part of the
Yes, yes,
finding.
yes, ma'am.
So this is the finding of fact.
Yes, ma'am.
Inquiry report.
Inquiry.
Finding of fact.
Yes, ma'am.
In a report, normally we don't interfere in
Interfere.
the finding of fact based on your mere oral submissions.
No.
Unless you have clinching evidence,
Yes, ma'am.
you have to rebut that. How will you rebut?
Madam, here what is the case about? He has served way back before the rule came into force. At that point, MLA has issued a certificate to the ST community because they belongs to Kui. Thereafter, the land records could not be changed, my lord. It has been stated as PANA. For that reason, this honorable court has directed by the Annexure 7, as page 41 in a common judgment to
They
direct
said, sir,
to
admission register.
an admission register doesn't disclose that I am PANA or Kui.
Serial number so and so, sir.
That is not correct, my lord, in view of the RTA petition on my lord.
I am asking you what was the query which was made.
And I will some file
You
it.
are, I know the way one can create a confusion through.
Yes, madam. But because I am not the filing counsel in this case, that has been only.
Once you have inherited the
Yes,
asset,
madam.
you
For
must
that,
inherit the liability.
for that reason, your lordship may give me 7 days time. I will file all the documents.
Say that I was not there,
No,
I
ma'am.
been there, the position would have been different. You
No,
can't-
madam. No, I am not saying so.
That is what you say, I am not a filing.
No, I will confirm that counsel that about the information he has sought for that application matter. So I
The
will file
one
an
thing
application.
is very, very certain in this case. At the time of a recruitment, there was a division of there was a post which was earmarked for ST. You offered your candidature in the post earmarked for ST. That's certain. You can't deny. The report says that you do not belong to ST, you belong to SC. There are certain documents which were produced, which shows that you do not belong to SC. You could not produce any documents to that.
Yes, ma'am.
You are not trying to use it. No, I belong to ST.
No, madam.
What you will say? You will bring 15 people of the locality who will come and say that you belong to ST. Does it?
No, that is not 15 people.
Under the Evidence Act, it
No,
is
madam,
a
it
quantity
is the
which
judgment.
materials or it is a quality which
But it
materials.
is the judgment as per this
Unnecessary-
honorable Apex Court, my lord.
No, sir. The one who has
Your lordship may see.
who has got an entry through a hidden door must be shown a very, very patent door.
Yes, your lordship, for a moment, page 43, your lordship may see the direction of this honorable court to change the record, my lord. Because due to we are not getting the certificate, my lord, caste certificate. Your lordship may see page 43 for a moment. May I read, my lord? By means of this, my lord. By means of this,
Just
my
how it creates a right.
thereafter,
You went there and you say that I wanted a correction of the record.
I am not.
I have-
Our community goes to the honorable High Court.
Whatever, then the court has simply rolled
Then-
the ball
There-
into the court or in the jurisdiction.
Thereafter,
of the
annexure-
authority to take a decision.
Thereafter, Annexure 3 as page 22 has been issued by the state government, my lord. I am filing, my lord, the English translation has not been filed. I have made the English translation, my lord. The lordship may see.
My brother is more acquainted with that. Don't worry. My brother will.
There a direction has been.
looking into.
Yes, there a direction has been. I have made the English translation today also. But there is a direction.
As per that is,
Yes,
मान्यवर उच्च न्यायालय निर्देश मुताबिक मान्यता दृष्टि कौन सी व्यक्ति कोई व्यक्ति नहीं अधिकार उल्लेख संसद और गाड़ी विचार को लिया जाए बारे केवल जदि
नामक प्राधिकारी যথেষ্ট प्रमाणिक दस्तावेज क्षेत्र अनुसंधान रिपोर्ट एंड प्रमाण संतुष्ट हुअन्ति जे तांकर जाति भूल अधिकार अभिलेखर पारण भाव उल्लेख करा जायछि so thereafter we have applied no till that it has not been corrected my lord. Till that it has not been corrected and as per the judgment no my lord as per the judgment of the honorable apex court my lord that should be taking into consider the customs and rituals my lord.
Oh, sir, who disputes? The question is that if you belong to a Pana or what is this particular no, not recorded Pana community, whether you follow the rituals of what is this?
There,
that is a different. Does it change your caste?
No, the petitioner case is belongs to
Sorry, I don't think, sir, we have given you a enough opportunity. You could not produce any documents. Absolutely. From the available documents and
social
as a social.
That's right.
Oh, why not? Then he admits. Is it? Have you challenged this? Page 47?
yes ma'am.
Have you challenged this? 45?
The report I have challenged my lord report has been prepared
Where
in the petition because before it has been prepared this has been prepared behind the back of the petitioner and the your lordship may see the objection I have filed categorically stating that it is the signature has been taken by the officer and I have not written anything else my lord. That has been
I am a illiterate person.
no.
When you put your signature, don't you understand that what is written there?
No, they have not written anything. For that reason, yes,
I am asking you, sir, when you put your signature on a relevant document,
yes, ma'am.
do you put it without understanding if you are a literate person?
It has been stated in the objection.
Something more is to be written at the time of signing the document.
It has
a ratification.
Yes, ma'am.
You have done it. No. Sometimes the bad cases are argued nicely by the counsel. You have done the best for your client. But you can't improve the facts, sir. What can be done?
May I submit the judgments?
Sure, why not?
Yes.
Why not? The judgments are very categorical.
Yes,
Don't worry. Yeah.
And taking into consideration this honorable court has also passed an judgment. I have
Yes.
because of hearing as well as the
Very recent judgment you have to consider whether there can be any other conflict.
and part one is honorable apex court in the case of Madhur Patel. The modification I am not given there.
So, after this, Madhur Patel case, 3 judges bench case has also.
That has been formed as part in
Thereafter Sudhir Batha.
yes in 2024
Thereafter Sudhir Batha.
yes ma'am.
After this, 3 to 4 judgments are come. Thereafter Abraham.
They have taken into consideration
How this judgment really helps you
because
of a Supreme Court.
But there
How it helps you.
but there it has been categorically stated relating to the taking into customs and rituals that it has been decided.
Please read that. What is written, sir? Show us. Sure. And the ratio is to be culled out in the context in which it is used, not one isolated or a segregated observations. Read the judgment, sir. What was that?
Yes, ma'am.
God. The instant case involves a serious issue where a candidate secure offering this last half recognition under the reserve category within the Caste. Though the documents put a law that belongs to a SC category. Though considerable, though the applicant served such post for a considerable period of time. But after an objection is raised, flagging such serious issue, the ball rolled into the domain of the operator. And determine whether the applicant belong to the ST category. The court never encourages the litigant to secure the public employment on the basis of a false declaration. And must be shown the why for his departure therefrom. Next, undeniably, the recruitment process was ensued for filling up the various posts, earmarking some of them to be filled up with a candidate belonging to a particular reserve category. Admittedly, the applicant offered his candidature as an ST category candidate without any supporting document. That is the certificate to be issued by a competent authority.
Well, at that point of that is not there.
Without and secured a merit position under such category. It is undeniable that at the time of the initiation of the recruitment process, though the posts were earmarked for a particular reserve category, but there was no insistence for the certificate to be appended at the time of offering the candidature. As such process continued on a mere declaration and or an affirmation made by each of the candidates.
Certificate has been given by the MLA, then MLA. That's what I'm telling you.
Whatever. Believing the testimony of the candidate, the authorities proceeded and offered the post to the applicant, where he rendered services for a considerable period of time. After the meet by the objector, made against the applicant, the authorities proceeded to inquire into the matter and taken into consideration the materials unearthed during the said inquiry from the record of rights in the public document, where the caste of the petitioner was shown as honor. What is this? PANA, honor, and not
Weak.
AU, not we. Admittedly, the honor is not included in the category of the scheduled tribe, but included in the category of the scheduled caste. There is a therefore difference between a person belonging to a scheduled caste and the scheduled tribe. The separate lists are prepared both by the central as well as the state, including the various castes within the circumference of the scheduled caste as well as the scheduled tribe. And unless a person is shown within a particular category, he cannot claim to have been included in another category. Next up, since the petitioner seriously raised an issue that the wrong end in the record of right cannot be used against his claim that he belonged to a scheduled tribe. Come on. A direction was passed in one of the repetition by this court. A direction was passed by this court in one of the repetition to consider whether the caste whether the entry wrongly made it relating to related to the caste is required to be rectified and or corrected. Till date, such record has not been corrected. We are conscious that the entry made in the record of right does not create any impact on the title of a person into the property, nor extinguishes the same. However, such entry has received such entry is sacrosanct with regard to the other aspect, unless contradicted with the cogent evidence. The record would reveal that it was all along shown in the records that the appellant belongs to a Pona caste and not we. We have a serious doubts on a certificate issued by to the effect that a person belongs to which category on the basis of the caste which he held. The law in this regard is well settled that it is the statutory authorities and the conscious decision to be taken with regard to a declaration of any caste within the purview of the scheduled caste or the scheduled tribe. Such certificate does not confer any right to a person. nor should be taken into consideration by the competent authority in this regard. Bearing in mind the aforesaid obstacle having manifestly blocked the road, blocked the path. The counsel for the appellate relies on a judgment of the Supreme Court, rendered in case of Kumari Madhuri Patil and another versus Additional Commissioner, the Tribal Development and others, reported in 1994, volume 6, SSM case 241, for the proposition that yes,
255.
yes,
5.
yes, I've seen that.
5. There it is instructed relating to cost
No,
of
this is what is the
observation.
relied on this judgment for the proposition also that an extensive inquiry is required to be made in order to ascertain the social status of a person and the role of the local inhabitants and the locality is one of the important facets of such investigation. The aforesaid judgment is cited for the proposition that the appellant was denied and a personal hearing and to bring the relevant witnesses of the locality who can throw light on the above issue. More particularly that the appellant belonged to Caste and not CORAM. In course of the hearing, it is arduously submitted before us that the appellant was all along following, observing, and performing the rituals attributable to a caste and not a Pona caste, and therefore cannot be treated as the person belonging to such caste within bracket Pona. So the judgment rendered in the appellate report does not appear to lend any support on the contentions raised by the appellant in the said report. No, sorry, the facts involved in the said report. It was a classic example of a misuse of the authorities of the misuse of the powers of these statutory authorities in securing in securing position, in securing the service in the public employment. The appellants therein being the daughters of one Lakshman Panduranga Patil, who was admitted in the school in 1943, and the register maintained by the school discloses the certificate as but they applied before the authority for issuance of a caste certificate as Mahadev Koli, a scheduled tribe. Such application was initially was rejected by the subdivisional officer, Bombay Suburban District, which was challenged before challenged by filing an appeal before the HARISH Content Division Bombay. Since one of the appellant was intending to offer candidature in the MBBS courts, claiming herself belonging to a ST category, the direction was passed by the High Court to dispose of the said appeal and direct the dean to permit her to appear for the interview and admit her in the college if she is found fit. It appears that the caste within bracket Mahadev Koli was declared as a scheduled tribe in the Bombay province as far back as in the year 1933. And by virtue of an Article 42, the President of India, in consultation with the competent authority, with the competent government, ratified the same. In of the adjudication, it was observed that any entry made in the record within the school records made prior to independence must be given a greater probative value and once the grandfather has declared having belonged to a Hindu Koli, the grandchildren cannot take a different view or different stand. However, even after having held that a person through unfair means and relying on a spurious document should not secure the admission in such a important educational qualification for scores, yet did not intend to interfere for the reason that she had already pursued this study and was appearing in the last year examination. It was expressly held that such a decision should not be taken as a precedent, as it is passed bearing the interest of the candidate who has reached at the verge of the educational course. Now, certain enlightening observations made in the said judgment is worth recapitulation. Having some bearing on the issues involved in the incident matter, Stop. It is categorically held that the authority should not fall prey to the tricks of the section of societies who started asserting themselves as tribes. And now, in order to earn the concession facilities reserved for scheduled tribe, it was held that such tricks are common and therefore to be judged on a legal and ethnological basis. Having observed so, the apex court here quote paragraph 13 of the said judgment. It's a longish one, but quote all. So far as the division bench judgment of this court passed in Marquez Malik versus State of Orissa and reported in 2011 within brackets supplementary to OLR 677 is concerned.
I have 6 man.
I'm reading that. Don't worry. The thing is cited by the minister only on the ground when there is on the ground that once the leads to a particular document, an opportunity to counter the same by addition of quoted evidence is one of the normal corollary of the natural justice, and therefore the authorities must afford an opportunity to the person who suffers an adverse decision to be given an opportunity to controvert or make an explanation on the document so relied upon by the authorities. In the said report, the caste certificate issued by the competent authority was sought to be challenged on a various parameters, and the proceeding was initiated on the basis of a show clause notice issued by the competent authority. It was never in dispute in the said case. The appellant therein relied upon the caste certificate issued by a competent authority, that is the Tehsildar, on the basis of a report of an RI of the concerned jurisdiction within the purview of the relevant statute. Stop. The moment the question, the moment the allegation is made on the genuinity, authenticity of the caste certificate issued by a competent authority, the principle of natural justice is ingrained and inherent into the system, and an opportunity is required to be given to the person who would be affected by the decision to be taken therein. More particularly, when the caste certificate relied upon by him is under a serious scrutiny. In the perspective of the same, it was held that since the caste certificate was issued by a jurisdictional Tehsildar who is competent under the relevant statute, based upon the report of the RI, which is sine qua non for such caste certificate to be issued, the proceeding of such nature demands the adherence of the natural justice and the opportunity to adduce evidence. Stop. In the instant case, there is no certificate which was relied upon by the petitioner, and therefore the genuinity and or authenticity thereof is not in question in the instant case. Case where the petitioner has been kept aloof from the entire investigation but was permitted to participate therein and to adduce evidence. Even a writ petition does not contain any such document when the approach was made before the single bench, nor we find any semblance of such document in the instant appeal as fairly submitted by the counsel for the appellant. as indicated here in our in absence of any counter evidence having produced, which would throw light on the genuinity, the sanctity, authenticity of the reports having submitted, the court should not apply the principles of natural justice in an abstract manner, as it is to be seen in the facts of the case and on the context in which it is so to be applied. The petitioner was all along aware about the entry in the record of rights, even was a beneficiary of the order passed by this court in the writ petition, where the direction was made upon the authority to take a decision on the correction of an entry made in the record of rights, and therefore cannot be said to be ignorant of the said fact. Till date, such entry has not been corrected nor declared to have been erroneously made, and therefore, the moment the matter was stopped. Furthermore, the jurisdictional authority has not issued any certificate indicating that the appellant belonged to a scheduled tribe and not the scheduled caste, as reflected from the various documents, and therefore, merely on a surmise and conjectures, the appellant is not entitled to a relief so claimed. Stop. We thus do not find any infirmity in the ultimate decision of the single bench. The appeal is thus dismissed. However, in the circumstances, no order has to pass. Okay.
Item number 4.
The appellant has preferred the appeal, challenging the order dated 3/9/24, issued by the Assistant Director, the jurisdiction of inspection ownership, as well as the order of the signatures, it was 4/9/31, 2020.
So the one question that struck you approached this court earlier against an order where your services were dismissed or revoked. The High Court interfered. I'm not making any comment on that, but interfered and set aside that order of punishment and directed the reinstatement to be done. While passing an order of reinstatement, the High Court could have done that you are entitled to all the back wages, you are entitled to all the salaries and the allowances which are admissible to you for the period when you were already terminated or under the termination.
That is not
If the High Court has not done so at that point of time, can you maintain another writ petition for that such relief?
no,
That I should be paid the entire back wages?
here, my allegation is
Only problem is order 2, rule 2.
yes, me.
Can you get away with order 2, rule 2? And then the explanation 4 and 6 of the section 11 also.
But the government rejected my application. After this acquittal, I approved for pension and other things, for salary and other benefits. The government rejected my application on the ground.
Probably you did not get it.
Right.
When you emerge successful in the earlier writ petition, in securing the setting aside of the punishment,
Only
can you not pray for all the back wages there in that proceeding itself? Upon reinstatement, I should be paid all the salaries and allowances which is admissible to me during my absence or a period of termination. You could have claimed. Cause of action is dependent upon that.
Judgment is adjourned.
On your having not, can you maintain a separate writ petition for that?
But after acquittal, automatically I am entitled to all benefits. After
That is what is a problem, because I have seen the rules. It says full exoneration and partial exoneration. I do not know. That's a factual aspect.
but this is not the partial, but that is not the partial. But Lakshman said the Anish
Oh no.
pay
this is-
75. Pay 75.
Now the recent judgment of that judgment after, say, the criminal proceedings. Honorable acquittal
Yes.
and the acquittal on a technical point. These are the two different facets.
But my case,
In case of an honorable acquittal,
yes. But my case,
That what is the judgment?
what is
Yes,
this
that-
tongue, GP tongue or GP tongue?
that is their law.
This is against
That
Jaipal.
is M. Paul Anthony was the first judgment.
But my case is completely different. The point
M.
that
Tongue
raised by
or
the
GP,
government.
what is this stand judgment of the Supreme Court? Honorable acquittal and acquittal
Yes.
on.
Yes, my acquittal is honorable. I will show that. I will show that. Yes, I will show that. I will show that. Right.
What my lord has asked you, that in the earlier petition when you had approached this court, basing on criminal case acquittal, in that petition, whether you have claimed back
Acquittal.
wages or salary during the period for which you were not in the job.
So, yes. That is not
So-
there.
So in absence of that prayer in the first petition, can this second petition be maintainable? That is what
Yes.
I think
Order
my
2,
lord
rule
has.
2. Order 2, rule 2 of the Code of Procedure. Just give him that book, EPC.
Even taxation is also a passing country. Relief, wholesome relief. One strong formula.
Give him order 2, rule 2.
Order court to order separate trials. Or it appears to court that any joinder of plaintiffs may embrace or delay the trial issue.
Order 2, rule 2 of the Code of Procedure.
Is order.
Rule 2.
Court may strike out the ad.
What? Now, अंगीकार करें. attack, you wanted to attack, in such former suit shall be deemed to have been the matter directly and substantially an issue in such suit. So if you could have sue for this relief and having not, then it will be deemed that that was there. And if it is cried, then why not? It's a denial. And once it is a denial, then section 11 will also come into play.
But
Then explanation 5 is also there. It says any relief claimed in the plain. Here you have not claimed relief anyhow, but any relief claimed in the plain which is not expressly granted by a decree, if there is nothing which is said, shall for the purpose of this section be deemed to have been refused. What to do, sir? Satisfy me on order 2, rule 2.
Yes.
Satisfy me on those explanations whether this type of writ petition is maintainable after you succeeded there.
But in criminal proceeding,
It's different, sir.
Yes, I understood that.
I think the principles of the Code of Procedure applies to a writ proceeding as well. I do not know what is the rule of 226. I had that idea of rule 53 of the High Court rules of 226 says it is mutant is applied. I think here also it will apply.
But
Principles akin to it will apply.
my case, let me permit to place my case. But
The case is as simple as a water in the Gangotri.
But
Very simple and very clear.
Here,
Sir, you were issued a show cause notice for a misconduct which you have committed in this.
Yes.
Which culminated into an order of dismissal or a removal from service, whatever.
Yes.
You challenge that order before the High Court. The High Court set aside that order of the disciplinary
basing on the conviction.
and directed the authorities to reinstate. As simple as this.
Yes.
There was no claim made by you in that writ petition that after the setting aside of the order,
Yes, I had claimed.
then you are also gone. Then more damage is now done. If then explanation 5 will go against you, then res judicata will apply, sir.
This honorable court.
So
Directed
my two questions were there to you. If you have not claimed that upon setting aside the order of the disciplinary authority and direction for reinstatement, I should also be paid all the damages. You could have claimed
But I
in
have.
that writ petition. If you have not claimed, then my point is order 2, rule 2 will apply. Correct? Second, if you have claimed and not granted by the High Court, then explanation 5 to section 11 will come. Again, you are out. Tell me which way I have to.
May I permit? But this honorable court, after setting aside the conviction order, I submitted I made the representation to the government to allow me to register service and give back wages.
Can you? That is what that is a fundamental and the jurisdictional point. Can you?
But thereafter, I came to the honorable court and the honorable court directed this
Can't.
the authority to come. I made prayer that gave me all the and this honorable court directed to.
Show me a judgment that you can. Unnecessarily, why be dilate when you are unable to comprehend what is passing through the mind of the judges? Please consider with the open mind what is troubling us. How to overcome with this.
Then let's call this after vacation. I will examine on this point. Answer that point. I answer.
Such a longer time you will take.
It's a question of bread and butter of my client. That is the problem.
Is a question of law first,
Yes.
then a bread and butter of.
Exactly. That's
So
true.
you are blessed with the order of reinstatement.
Yes.
You could not, I think, appreciate my observation that I am not making any comment
No, that's true.
in the earlier orders.
No, that's. But after vacation, I'm reasonable. That point. So because what she called this meet. Then I have to wait the answer.
Utilize the weekend and come on the next Monday, I can give you a time. It's a pure question of law. I tell you very frankly, if you can satisfy the court will not look into order 2 rule 2. Court will not look into the explanations of section 11 in the writ proceedings. I will admit it. Assure you. I'll admit it immediately. And we'll hear out. Because that requires then an interpretation of the partial exoneration and the full exoneration. Then I will consider thereafter. But this is the hurdle. Come on Monday.
Monday.
You are without job. Now you are with job, without any money. You said, look, I am without money. You are getting the regular money now, only past.
Only 10,000, 12,000 money I am getting. Whereas I am getting 1 lakh salary.
Mr. Patnaik.
If that will be calculated.
Mr. Patnaik,
My
have
lord.
you seen the docket note? Mentioning only this matter was.
Yes, that's true. But I
So
just
So now-
answered
now
my
you are
last scoring.
Now you are asking for time when a court has put a difficult questions to
Yeah,
you.
definite for me. Definite.
No,
I'll meet.
then we will not allow mentioning.
No, I'll meet that answer.
Oh, I did not
Definitely.
notice this. That's a very good of this court. At least the cost title reflects that how this matter has been listed.
That's true.
We had no idea about it.
My lord says, my lord, just appreciating my memos. That's question of. Yes.
On the prayer.
Yes.
Item number 5.
Yes.
One,
Oh, he's asking for that. Let us see. Yes.
additional affidavit one has been
Well, after this.
with the simple matter that
Yes.
prayer for voluntary retirement rejected, challenging that rejection to the appellant approached the Honorable Court, that was rejected, is returned. But just now, my lord, I haven't given one additional affidavit 5 minutes back only.
Additional evidence is 5 minutes back.
5 minutes back only it was given.
What are you doing?
My lord,
You have sought for a leave.
5 minutes back.
D'accord. Leave is granted to the appellant to file the additional affidavit. Let the same be taken on record. The counsel for the state respondent submits that the copy whereof has been served few minutes before in the open court, and therefore he needs perusal thereof.
12th.
He needs meticulous examination of the averments made therein. Stop. When
On 12th.
matter to be listed on 12.
Sir, these documents were not before the writ court.
It was there, Your Lordship, but
Then why additional?
I just wanted to press Your Lordship that
For some good. Yes, call.
Item number 6.
May it please your lordship, sir. My lord, this arises out of a dispute regarding a mining matter, my lord. Supply of goods by a mine owner, agreement to sell to our clients, my lord. So what happened was, my lord, this matter went to arbitration of Justice A.K. Patnaik, retired Supreme Court judge, my lord, and objection was taken by them, by the respondents. After interplay, as your lordship knows, it is now the arbitrator who decides the stamp objection. Earlier it was, and in global it was the court. Now the interplay.
3 times.
3 times, yes. That's right. So now, end of the day, it's
Seven judges.
7 judges. So interplay 7 judges, now finally has been given to the arbitrator. So the arbitrator, my lord, after considering the facts, went into the question of whether Article 5 or Article 23 applies. Article 23 is a conveyance, Article 5 is an agreement. My lord, the learned arbitrator, on considering the nature of the agreement, that it's an executory agreement, it's an agreement to sell. So the lordship would appreciate at the time of the agreement, where the arbitration clause is contained, there was not even a mining lease, so there was not even title to give away. Anyway, be that as it may, my lord, the reasoned and considered judgment was that Section 16 application was dismissed, and not dismissed, it was held that the relevant article was Article 5, and stamp had been duly paid. So there was...
The arbitral tribunal is still in the session of the matter.
Arbitral tribunal, my lord, this objection was taken after all the pleadings had been completed and the evidence was just about to be started. And that's
Is it
still
an
the
interim order award or it is the interlocutory order passed by the arbitral tribunal? Ruling on
Section 16 order.
16.
Section 16 order has been passed.
Is it susceptible or amenable to be challenged in Article 226 or
My lord,
227?
it was challenged and it was set aside.
Is it susceptible? After
Well,
SBP and
strictly,
Patel
yeah.
Engineering, I'm just thinking about that judgment of the Supreme Court, SBP and Patel Engineering.
Yes, that's right. Patel Engineering, then Deep Industries, then Bhaven, and then EMTA. All of them say that in the rarest of rare cases where there is bad faith, there is a narrow window opened. But according to me, after SBP,
I
the
think-
7 judges, it cannot even be touched at all. The only state is
Absolutely.
Section 34.
This is what?
Yes, Your Lordship,
2005 volume 8 SCC. I
Yes,
believe
yes.
so.
We have them all, my lord. Section 34 is the appropriate section says so. But nevertheless, the learned judge went into this. That is our first point. The major question.
So let us hear on this. How can a writ court interfere? Constitution bench decision of the SBP.
I appear for the respondent and my lord.
How?
You are in caveat.
Yes, ma'am.
So how can it be done, sir? After this judgment of the SBP Constitution bench, which really forbids any kind of a 226 or 227 application to be entertained against every order of the arbitral tribunal.
May I answer, my lord, straight away? The Supreme Court has carved out an exception in Punjab State Power Corporation versus EMTA Coal, expressly saying that in exceptional circumstances and when there is perversity, namely in this case,
This can be agitated in Section 34 after Justice Nariman's judgment.
Lord, this is
That perversity can also be raised.
but for 227. I will satisfy my lords on that. Can I make one suggestion, my lord? I am
Yes.
physically there on Friday. If my lords find it expedient, your lordship can have it on Friday. I'll physically assist my lord. We have all the judgments to show that this falls in the exception.
Proceedings have been stayed. Your Lordship will permit the proceedings to continue, my lord, when at convenient date. Nothing will happen. We are not running.
Because Section 16 that the arbitrator can rule out its own jurisdiction. There is no difficulty. Section 16 talks about that.
My lord, I can just bear with me for a minute. Your lordships have asked the most pertinent question. There is a category 16 being challenged in a 227 for which the Supreme Court has carved out one exception, namely, my lord, perversity or in exceptional circumstances. The exceptional circumstances is that the tribunal did not follow the judgment of the Supreme Court in the 7 judgment case in NL Global. That is why, my lord, it comes in the exceptional category. A document, my lord.
We are more on a jurisdiction point.
Yeah.
There is no doubt that certain issues which comes within the purview of the perversity or the exception, those can be definitely taken as a point to challenge the action of the arbitral tribunal. But what would be the forum and to what stage or at what stage?
I will satisfy you both, my lord. The forum will be the arbitral tribunal and the stage will be a section 60.
Well, I think this proceeding to continue, my lord, is being just kept stuck, my lord, in the time frame. And then we are not leaving, your lordship.
When this order was passed?
In February, 25th.
25th February.
Half
My lordship, may I suggest this?
So-
the award not be passed, the award will not be passed, there can't be any. Then your lordship.
No. In this, the writ petition, they was entertained.
Yes.
The order has been set aside.
State, and it was sent for impounding, sent to the collector, assessment of duty, all sorts of things were done, which could never have been done.
But the difficulty is after the NN Global, Section 33 and 35 of the Indian Stamp Act, that will be attractive. And it talks about that.
I'm not, arbitration is held on it, my lord, isn't it?
And it is started with SMST judgment for the first time. Section 35, you find a distinction between 33 and 35. 33 never talks about acted upon. 35 talks about acted upon.
Absolutely.
Now, whether it can be acted upon is the real issue.
Correct. You know, the document.
And in the meantime, many judgments after SMST has come, giving a different color.
But it's a curable defect, my lord. The arbitration can proceed, the defect can always be cured.
I think Garware is also one of the judges.
Yes.
Absolutely. My lord, my learned friend has answered the question posed by himself. He says it's curable. He has to go and cure it.
No. Mr. Counsel, there cannot be any doubt in the proposition of law that this Stamp Act does not really create or diminish the right. It simply says whether the court will receive a particular document in evidence. If the document is required to be stamped and it has not been stamped adequately, or say without stamp. If it is to be impounded, then after the impounding, there is no difficulty in proceeding. If it cannot, but
the question
should I digress a little bit to both of you? There is one point which always grapple me, that whether this impounding is imperative at the interlocutory stage, say for the purpose of an interim application.
My lord, it will touch upon the
there is, I believe, a judgment in Calcutta High Court. I believe there is a particular judgment in the Bombay High Court which says that pending some interim relief.
No, that was a full bench judgment authored by Justice Kulkarni.
Yes.
There is no difficulty. Two questions were there. In Garware, it says one is in affirmative, one is in negative. I could not figure out what does it mean. And all the judgments have been silent on this aspect. Even a 7-judge.
I hope this particular case doesn't raise that issue. Because section 16 is...
I say a little digression. I know it. I say it's not there. There's a little digression. Because this is a vacuum which is still created.
Not been clarified. Your Lordship is
it's a vacuum. So can we go into that aspect also?
This touches upon the existence and validity, and the Delhi High Court has also considered this issue. It's an interesting point of law. My Lord's comment.
The question is whether it should wait for section 34. First question. It should wait for this. It should wait for section 34. The judgments say, except in very, very rare cases, SBP says it has to wait for section 34. There's no rarest of rare case, 7-judge bench. Later judges 1 or 2 have said there's a narrow window, but even in those judgments, it did not interfere. And it's impact, my lord, is a matter of it can never be such a patent illegality that no court could have ever come to this conclusion, my lord. I don't think justice, but like the adjudication falls into that category of absurdity.
Only thing is it has to be kept, I would say, in abeyance till the impounding is done. That's the sole motto of the entire aspect of the stamp duty.
That is provided the judgment is wrong. That is provided Justice Pandayak's judgment is wrong. The arbitrator's judgment is wrong. He has held on it. He has gone into it. He has gone into it on merits. Now, on merits, he has taken a view. My lord, whether that view can be substituted by the court in this jurisdiction. That's the first question. When the courts have said it should wait for section 34 adjudication. That's the language of section 16. It is very, very rare. SBP says it never be interfered with because it should be, you have a remedy at the stage of section 34. That is the appropriate stage to take the point. That's the main question for my lord. And second is, can one substitute the entire view and come to a completely different conclusion by analyzing the agreement?
No, he wanted a physical hearing.
So then your lordship, lordship passes some order allowing the arbitration to continue, and lordship keeps it on Monday.
Now the difficulty is that the arbitration is allowed to continue.
You're asking.
Ultimately, kindly resolve because the word acted upon appearing in section 35 of the Act, that really acted upon means even a first step to be taken. You look at distinction between a language. Have you seen the language between 33 and 35? It's the same language, except one word which is acted upon.
But he has taken a view, my lord. The arbitrator has taken a view that it has been correctly stamped. It's not a question of unstamped. Correctly stamped under Article 5. That is his view. There's a stamp. It's not an unstamped document. So
but not adequately stamped.
According to my learned friends, and which he has rejected. That finding on analyzing the agreement, the arbitration. Lordship appreciates one thing. At the time of the arbitration agreement, there was no mining lease. There was no title to pass. It's absolutely absurd to hold that at that stage a title is passing and it's a conveyance. My lord, it is, I would say, impossible to hold that. But in spite of that, my lord, the court has held that and reversed his finding. So, my lord, I mean, really, it's a finding. But whatever it may be, my lord, this is a view taken by him. It should
now, the only thing is if he asks for a very shorter time to ponder upon the things, so that is why. And you have waited for time. If you have waited for such a long time, I think 1 week or 5 days or 6 days
Very well.
makes
Lordship,
no hell.
I am in difficulty on Friday, or I'm coming for this. Lordship gives it on Monday.
Monday.
Monday is a holiday in the Supreme Court, I believe.
Oh, that's fine.
It is open here.
Whatever suits my lord.
Sir,
Yes, my lord.
no difficulty.
Absolutely not. We will have the privilege of assisting my lords.
Oh, a privilege of hearing all of you. That's
Yes, but as my lord rightly, it's ticklish. Let's hope we can resolve the little tickles, my lord, because there are judgments which, exactly as my lord said, acted upon is the key word. So I'm requesting the court to act upon, acted upon versus what.
I'm requesting the court to follow section 16 and 30.
I tell you, before this SBP came, my view was that even after SBP, my view was that an interlocutory stage, the short court should not insist for impounding of the document. But that view appears to be reaffirmed to receive revalidation. May I use that word? Because I have also doubts on that.
Lord, we'll assist my lords on Monday.
Monday? An interesting point is raised in the instant writ appeal. Whether the writ court can interfere with the order passed by the arbitral tribunal in exercise of powers under section 16 of the Arbitration and Conciliation Act 1996, or should have refused to exercise jurisdiction under Article 226 of the Constitution by permitting the parties to raise such points under Section 34 of this Act. The counsels appearing for the respective parties insisted for listing of the matter for final disposal, as the point indicated here in above are purely a question of law. In such view of the matter, let's list the same on Monday. To be taken up at first.
First, like deeply.
Yes, sir. That would.
Deeply grateful, my lord. Extremely grateful.
The weather condition is also good now after the heavy rains. So enjoy.
I beg your pardon, my lord. I was not able to hear.
I said the weather conditions here is also good after the spell of rain since last 2 days. So enjoy the weather here.
Yes, absolutely. Lord, we want smooth sailing. Wherever we are, we want smooth sailing.
Yes, bring all those line of judgments. I think SBP was one of the first.
Yeah.
And then SMST was the first on this impounding of the documents or acting upon the same. Then
note of
series of judgments, Garware. Then there was another in the meantime, I think before NL Global.
Lord, we'll prepare a update.
There was 1 or 2 judgments.
Lordship of the question at the stage of impounding, whether it should be now or
True.
Apart from the basic question which my learned friend has raised, whether it
No, that is another, whether the writ court can, that is one issue. But I also want to decide on the of impounding.
Assuming that the arbitrators.
Suppose section 17, interim order.
When should it be impounded, if at all?
Section 9.
But 16, my lord, subject to what my lord feels, is more or less final in nature. It is not really for protection of.
No, it's a ruling of the jurisdiction itself.
Yes, of course.
Section 16, he really ruled out the point of jurisdiction.
That's right.
So that is one thing, because he has to carry forward. After
the next stage.
It's the next stage.
Very well.
It's like a demerer applications.
Right.
It's like in the nature of a demerer.
My lord.
Thank you.
Item number 7.
Whatever. We don't write anything there, so that's why.
I'm saying there will be,
Yes, Cousins.
Item number 7.
since Mr. Gopal Jain, along with Spandan appeared, and the matter is finally to be heard on so bit, the clarification is discharged.
Yes, sir.
Six. In this case, my lord, the appellant is in receipt of block grant.
Is a
Is in the receipt of block grant, not in the regular grantinate form. Because my lord, under this Odisha Education Act, prior to 2004, my lord, there was a salary of the employees of these aided institutions are at par with the government institution employees. But however, the government brought in a new scheme, to curtail the, because the government is giving grantinate, that is in the 40% of the salary components is only paid as in the nomenclature of block grant.
block grant.
Grant.
Okay.
That 40% of the total, their nomenclature is block grant. The 40% of the salary. So therefore, the service condition of the regular employees, those are in the full cost of grantinate, governed by a different set of rules, which is not applicable to the petitions or the present applicant.
Even prior thereto.
Yes, such type of institutions.
So even prior thereto, the service conditions were different. Only thing is the pay scale should be at par with the government employee.
Employees. That is called direct payment. The nomenclature was direct payment.
And the government, while extending the aid or granting the aid, they were giving the full. Now they decided to restrict it to 40% of the.
40%, it is enhanced to 60%, but it is not at par.
Okay.
As of
Given
today.
to institution. Given to institution, not employee concern.
An employee that ultimately comes, but it not a 100%. It comes in a part. I am such an employee. I am getting 40%. My salary was also, my service was also approved. And kindly see, my approval is under a different order. It is 14.
Then
I was approved and I was given the bulk amount, that 5,000 somehow. Now what my difficulty is, I am a clerk. I have been continuing in any particular institution. The Annexure 3 order was passed by the director
of
the Higher Education Odisha, who is actually the cadre controlling authority of the aided institution employee. So far the transfer is concerned. Because there is a set of rule governs the field with regard to the employees of the aided institution. So far the transfer is concerned. That is, my lord, if you point at it.
No, what is a grievance? Let me understand the grievance. Then I will go into the law.
Okay. Now, my lord, the rule governs the field. There is a provision for transfer of the employees which are giving the full grantinate.
Full grantinate transfer.
There is a rule. Even if considering for a moment, if that will be there, the rule says unless and until there is a cadre, common cadre constituted by the authority, nobody can be transferred. And furthermore, in that particular rule, my lord, there is no provision for deputation. Nowhere it is there that one can be deputed to another institution in the guise of transfer. That is the rule, sir. I will take my lord to the. But this petitioner, while continues in a particular institution with his block grant, the Director of Higher Education on 10/3/25 directed deployment to another aided institution, which I object because this is not permissible. Even normal course I could not even transfer. There is no provision of deployment of such type of employee. So this order is without limit. That is my challenge. But the Honorable Single Judge decided the matter, taking note of this fact, my lord, but said that because the war administrative exigence has been reported there in the order, so you go and join there. That is my objection, my lord. My response submission is so limited, even in the case of transfers, my lord.
scope of the employee to assess. If it is illegal, I can come to my, or if it is malafide, I can come to this honorable court. But otherwise, I could not have come. But here I am saying that this is illegal, and the order is without jurisdiction of the authority. Therefore, I want to bring my lords to the rules first. Considering at this moment, my lord, I am even an aided institution employee, and the government has also issued a clarification. I want to bring it and dated so, but the circular I could not get it, and the finally giving copy. They have issued a clarification also. This type of employee cannot be transferred. But kindly have a glance. The circular the government has issued 1 page. I have annexed it. Kindly see, madam. This is available in 16/4/22. The secretary issue. Subjectly transfer of the employees receiving granted under GI order 2004, 2008, 2009, 2014. I am in receipt of GI order 2009. There is a doubt in certain.
Oh, I got it, because they do not constitute a statewide common cadre.
Yes, that is the
So they cannot be transferred from one institution to another.
There is admittedly there is no common cadre as of today.
So now the first thing is that whether this particular non-government college is getting a grant in aid in terms of the GIA order 2004, 8,
I am in 9.
and
I am
14.
in 9. I have received that was given the approval order. I am in receipt of block grant or GI order 2009.
That's why I'm saying
Yes.
whether you come within the purview of any of it.
Yes. So now I will kindly have a glance to
Yes.
the rules. It is 505 of that book.
Yes.
That is called the Orissa non-government.
No, I got it. You need not have to show me the relevant
Mine. That
the
is
rule.
similar. Common cadre is defined under section, so rule 3E, small e. Common cadre means common cadre of ministerial employees of non-government.
No difficulty. Non-government aided colleges in respect of a revenue service.
Mine.
This,
Now,
that
the common cadre,
section
all
4,
ministerial,
rule 4.
Common cadre, all ministerial employees, junior clerk, cashier, junior account, senior clerk, head clerks of the non-government aided colleges.
Separate cadre.
Within the
So
revenue
naval
district,
part. You are
they
coming.
separate cadre.
You are coming under.
Bhadrak district. Revenue district, Bhadrak.
No. You are coming under a junior clerk, cashier, or what?
I am a junior clerk.
Junior clerk.
Mine.
Yes. Then
So, I
you want a separate cadre. No
there
difficulty.
is no cadre. So now,
Shall form a separate cadre. Anyhow. Then
now I will kindly turn to the seniority and transfer is route 13.
correct.
Directors shall have the power to transfer ministerial employees of non-government aided colleges born in the common cadre from one non-government aided colleges to another, as and when deemed necessary.
Correct.
No employee having less than 3 years of service in a particular non-government aided college shall ordinarily be transferred,
True.
provided that such an employee may be transferred before the completion of 3 years service in the
And administrative exigencies. So you have completed 3 years or not completed 3 years?
I have not completed. I have less than 3 years service to go for retirement. That is this tenure. Less than 3 years service in a particular shall ordinarily be transferred. That is, I have completed more than 3 years there, but I have only 3 years service left to retirement. And now it says that he can transfer me only.
So you are coming under sub rule 2, and then you are taking advantage of proviso.
No, I am.
No, you are
saying
yes.
The main check.
Correct. Common cadre. Yes.
My response submission is till date there is no common cadre
Got it.
of ministerial staff of Bhadrak district or in throughout the state. There is no common cadre of this block grant employees, which is also corroborated from that government circular received on 16/4/2022. So in such circumstances, I should not have been transferred. But this is not a transfer order. What it the 3 says deployed. My response submission is in the statute itself. There is no such provision deployment. So in that contingency, I don't know, and there is no other person also in that institution. I am the only clerk now continuing in that particular college, wherefrom I have been directed to work in another institution on deployment basis. So since my response submission, if the authority has no power to transfer me, and there is no such provision in the statute to deploy a person, so this order is without jurisdiction and illegal. That is my submission. The court, single judge, has held, because it is administrative exigency, go and join, thereafter make a representation to the authority, they will consider. Or he has passed the order, if I go to him, definitely the result is.
Why?
But definitely, because one, the court has said, can you see the order?
Why? There is every possibility of changing the mind.
Case, my lord. Can you see paragraph 6 of this judgment? Page 19. Sorry, order.
Yes, what do you say, madam?
First of all, my lords, the appointment letter is issued by Director Higher Education Officer.
No, he's the authority who can transfer. What he says is that in absence of any common cadre, the provisions of section 13 cannot be activated, cannot be resorted to. So he's in an issue which goes to the root.
Here, section 13, the head note talks about transfer and not deployment, my lords. First, my
Head note does not control the enabling provision, madam. Head note may be supplying some kind of a, the intention of the legislation, but does not controls the enabling provision. Enabling provision talks about a common cadre.
Yes.
He says that I do not born of a common cadre. If I am not born of the common cadre, then how this can be done? Section 13.
If I may,
Rule 13.
if I may lords, refer to para 5 of the submission which was made by the learned counsel appearing for the state, because this was dismissed on the first day, my lords. So in the submission referred is the deployment order is only on the ground of administrative good.
No. What he says that yes, that power is still there. Director can exercise such power on an administrative exigencies. In what respect? If a person is born of a common cadre, then you can do it. He says, I am out of the common cadre. If I am not, then how exigencies, how section 13 will apply? This is what he raises a basic question. You can, your power is not doubted that you can. But what he says is that if I am not under the common cadre, how? And secondly, he says that proviso is there, no doubt, which does not talk about anything about deputation. It talks about a transfer, and you have put him on deputation.
Basically, my lords, the main point which I was trying to draw is section 30, which talks about transfer. The word transfer is also mentioned in the entire provision. So this refers to transfer, my lords. And the order which was challenged before the writ petition, where the order was deployment on administrative ground, my lords. And
So that deployment, where from you got? You have to have a rule. You have to act within the four corners of the rule.
my lords, the
If
submission,
rules doesn't permit you for deployment,
my lords, my submission is that there is no specific provision for deployment. There is no specific provision for deployment that does not rule out the power for deployment.
Madam, to that extent, we can appreciate what it is that the posting on a deputation does not come under the transfer, or it is outside the transfer. We can appreciate, may not agree with them, but the basic point is whether he is within the common cadre. What is the meaning of the common cadre? And the definition says that there should be a cadre, common cadre, of all ministerial, the post.
Of junior accountant, clerk, cashier.
And then it says, no, it talks about a separate. Please consider common cadre and a separate cadre. What is the meaning of the word separate cadre?
If I may request, my lords, in this matter, there is no counter affidavit which was filed before the writ petition.
It's a pure question of law. Madam, it's a pure question of law. It simply requires an interpretation of section 2E, rule 2E, rule 4, and rule 13. Nothing more than that.
With respect to what kind of service he is doing. And
Junior, he says that it's not dispute, junior clerk.
And exactly which rules are exercised in his case, applicable to his case, all those details.
It is a non-government, non-aided, I think, the college.
Aided college.
Oh, sorry, it's a non-government aided college.
There is no
Non-government aided college. He's not denying. And if it is not, then how can you exercise the power? It's not a government college. It's a non-government aided college. You are giving an aid, maybe partial or full. It's an aided. Huh?
Pilots, if I may draw your attention to para 6.1, which is the final finding of the learned single judge members at page 90. However, it is open to the public.
Is what we are asking you. You have to act in accordance with the proper rules. Unless the rules permit you for deployment, can you exercise that power in the garb of transfer? In the garb of transfer under Rule 13.
That's one chance may be obtained. I'll just take instruction whether there is any specific rules or circulars regarding guidelines regarding deployment also, my lords.
No. Madam, probably we have not been very clear and we could not percolate a very clear message to you. He has proceeded on the basis that this rule, which is the Odisha Non-Government Aided College Ministerial Service of 1999, is applicable. He says that director is empowered under this rule to pass an order for transfer. He admits that yes, I am not questioning on the power of the director to transfer a ministerial staff. But if he is not born of a common cadre, which is one of the requirement under the rule, then exercise of power by the director is absolutely illegal. And if it is an illegal act, then in that event, the court can interfere. He says that power of the director can only be assumed if the employee is under the common cadre. He says there is no common cadre as of now. If it is not, then how the director can exercise its power? That is what his contention is. I think I cannot place it as simple as I have.
I understand the query which is falling from the bench members. The only submission which I have here is my section 4.
Don't forget about it. Exigencies is an elastic word. It is within the domain of the employer how to understand that exigencies. Employee cannot control if it is a transferable job. It is absolutely a freedom of the employer. This administrative exigency, we are not going to interfere. What does it mean? Very clear. He may argue many things, we are not. Very clear. Otherwise, no administration can be done if everything the interference is called. But only thing is exercise of power by the director. How? Yes.
Permit me
Sure, why not?
transfer and deployment. Transfer, change of station. Deployment, you will be posted there in place. Transfer, deployment are not the same. Transfer. 1 minute. Transfer unless until common cadre.
I have a query. I just wanted to give you a free hand what you want to say. Then I will put a query. You are trying to make a distinction between a transfer and a deputation.
What I was saying, my lord, possibly, I do not know, possibly there may be a guidance for the purpose of deployment. That was what she can procure from the government.
That he would remain the employee of that particular institution, but rendering services somewhere else, and his services or his salaries are drawn from there. Then second question, there is guideline on this. You are a statutory authority. The very fundamental principles in the jurisprudences, an authority cannot do anything unless conferred by law.
Yes, sir.
An individual can do anything unless forbidden by law.
Yes. Definitely.
That's the most fundamental principles one should know. So you have to show the source of power.
That's what I am asking.
Sure, sir. Even in case of a deputation or deployment, source of power.
Whether the director is empowered.
Source of power.
That's what I was asking her to take the instruction as to whether.
Give us when tomorrow, find out.
Tomorrow they have to.
Very difficult. Very difficult. Anyhow, a day after tomorrow, on the prayer of. Few days, sir, you have been there. Sorry. It will remain, it will remain.
Item number 8.
May I please be pardoned?
Release of vehicle is on the section 52 of the Odisha Excise Act. And the mere confiscation proceeding, initiation of confiscation proceeding, the London court below rejected the application on the section and the seizure and the confiscation notice has been served at page 26 annexure 6 million. For that reason, the London court below rejected the application and same has been confirmed by the London ADJ in division below. Thereafter, the approach before the Honorable Court in writ application, my lord.
Where is the order?
My lord, that order we have not challenged, my lord, in annexure 6 at page 26, initiation of proceeding was challenged and the lordship has a.
No, you said that the writ petition before the single bench was filed. Where is that?
This is the maximum assigned to the single bench in vehicle release matter. It has come before my lord.
Item 8.
No, writ petition, what he is talking about? Assigned to this bench or something, I do not know. It's a single bench matter. Brother, you know better. Is a single bench or a division bench?
Excise. Excise confiscation. It's a confiscation. हो दीजिए सर हमको ड्राफ्ट करके दीजिए सर क्लियर कर दीजिए
Which?
It is emanating
from an excise case. Possibly it is before your lawsuit in the division. Because I have put some cases.
No, it's a confiscation.
Yes, confiscation of the vehicle. Going out.
So single or division? Question is not whether the writ is entertained or not. The question is who will entertain.
Yes.
Single bench or a division?
Yes. You days back, I was arguing a case before the lawsuit that Mola says conviction of that vehicle that emanated from the excise act. So it was taken up by.
So this point was not raised, but now he is raising a single bench or a division bench. So that's why I am not very much aware of the procedural of maintainability before the single or division. So
all the confiscation in first case or excise case.
'To seizure and release of vehicles except SARFACI Act. That's of
Justice
S.K. Panigra.
Chapter 3 of the Odisha High Court rules, please. Chapter 3.
That will go to Justice S.K. Panigra. Petitions relating to seizure and release of vehicles except under SARFACI Act. entry 6, entry 5, your lordship. Oh, this is funny.
Except under the surface means then everything. So that's section 14.
Seizure and release of vehicles. (457) CFS. So civil return, that is also seizure.
In the report of the staff reporter, wherein it is indicated that the subject matter of the speech in the instant restitution is required to be dealt with by the division bench. So our attention is drawn to the roster, drawn to the roster assigned to each of the benches, wherefrom we find that in terms of Chapter 3 of the rules of the High Court of Orissa 1948, the seizure or the release of the writ petition relating to the seizure and release of the vehicles, except under the Surface Act, is to be dealt by the signatory. The report of the staff consultant is ignored. The matter will be placed before the single bench having an appropriate roster.
Item 9.
This was placed to carry out the order of the collector. Connection with the page 59 on the website. Collector in the WPC. Why is the madam who's the parent? He wanted your own order to be implemented. This is what you want. You wanted the order of the collector to be implemented. To be implemented. It's your order. You have to implement it. Why you are not implementing?
Lordship, there was an inquiry also conducted. I have to seek instruction.
No. You wanted that there should be order dated 5/8/2024.
Yes, Your Lordship, there pursuant to the order dated of His Honorable Court on 7/7/2023, and the collector passed an order where the Tahsildar Nishanpolia has also submitted his.
No, it says that immediately to start the eviction and make the government land free from encroachment.
An eviction
So now
eviction case has been filed. Yes, Your Lordship. I have to seek inquiry as to the present status of those eviction
so it
cases.
has been filed. Can you show me the documents? Has it been filed? They have initiated?
Yes, Your Lordship. The Tahsildar has written in his report.
No eviction proceeding. He has raised a grievance that till date no eviction proceeding has been initiated. Page 28 of the writ petition paragraph. It's the penultimate paragraph. It says.
I will seek instructions, Your Lordship. I will seek instructions. Let it come day after tomorrow.
Day after tomorrow. Matter to be dismissed day after tomorrow to enable the council to receive, to take instruction.
Item number 10.
Then, my lord, inspection of that community center, taking a piece of land from the school area, so also another piece from the road itself. Your lordship wanted me to take instruction. Already have taken instruction, it has come. Now they are going to demolish Actually,
any
actually a
which has-
concession has been made there. The water can issue.
So, no difficulty.
Yes, if that is so,
We can dispose of the matter.
also temple adjacent to
Yeah,
the.
Plus everything.
In that first page, my lord, what's the last portion, para 5 response. It is humbly submitted that necessary
Yes, Amin was there.
Sorry, ma'am.
Amin was deployed.
Yes, ma'am. That is an the corresponding have been made video bottom up or demolition.
What is this Kadi or whatever?
Body.
Kadi.
What
Again,
5 Kadi, 1 Kadi equivalent to
Chain.
1 Kadi is equivalent to.
Point exactly.
There must be a measurement of the land.
Yes. 8 inches.
about 2 inches of the
9 ratio. 8 inches.
Sure. My friend said 8 inches. I am not
8
sure.
inches.
No, I am also not. 7.92 inches. Google says.
So 8 is 7, very nearer to 8. Yes, 7.9. Anyhow. And what is this khata number is where the name of the person with the plot number is recorded for the purpose of land revenue.
Land revenue. Khata is bigger area out of which plot number have been given. Different plots. On the one khata, there may be different plots.
Do you use the term Mauza?
Mauja, yes, we don't use the Mauja. It is also there.
So Mauza
Your lordship
is a larger area which contains several plots.
That is Mauja means village.
Okay.
Revenue.
The revenue village. It is also.
And khata is?
Khata is a particular patch of land under which different records are there.
Particular book.
Khata, I normally know about a book.
It is a
So
book.
in one
Register.
book, in one register, yes.
Yes.
Khata is one register. If it is the one register, one large tract of land is recorded.
Yes.
And may consist of several plots owned by different persons.
Yes.
This is khata.
Yes.
And what about the register or thing maintained for each plot owned by a person?
Khatiyan.
Khatiyan. I know this. This word is also there.
So there.
Same word. Then I know. That khatiyan.
That is our word.
Is there any law? There, the law is that one man, one khatiyan is the law.
Yes.
Suppose if he owns several lands,
Here also,
Yes, here.
there will be only one khatiyan, which will
particular.
engulf
different-
all the lands,
If land.
maybe in different maujas.
No, not.
Land passbook. That is introduced, whether it is
Not in.
it is in effect or not, I do not know. Land passbook is there.
Land book has it's not given. It has not.
No. In West Bengal, they have amended. There will be a one khatiyan for one person.
No. It is not. It is not.
So if that person owns, say, 5 land or a 7 land or a 10 lands, maybe in one moja, another moja, different plots. Everything is recorded in one khatiyan.
But here that is not. That has not been implemented as is not.
Yes. Oh, so they have already decided.
Decided. Business.
No, it is already constructed up to the roof level in plot number 20 of the khata such as which one clarification is sought from the area as intimated no funds have been released for the deal. This first one is paragraph 3. A release temple building has been made by encroaching 15 kadi of land to the boundary and 5 kadi of the village road. That's such a symmetry. It is which district?
In the district of Cuttack.
Cuttack. What to do? Should we keep it pending or? They have no. Madam, we are disposing of.
Yes, ma'am.
Unnecessarily don't keep this matter.
No, madam.
Because they have already redressed.
Kindly
They say that they have found, yes, it has been done and they are contemplating the steps for demolition.
Only, my prayer is only time frame may be given so that
How
they
can we give a time?
Then the corpus, they will, if they will not demolish it.
No, we will record their stand.
Yes.
And we'll say that within the reasonable time, they have to take steps.
That you got.
The instant public interest litigation was initiated at the behest of the petitioner, raising a grievance that in the garb of the expansion work undertaken for Tarini Temple, they have imposed upon they have imposed upon the land belonging to the school as well as the garment without following any procedure of law. Since the expansion of the temple was undertaken, obviously keeping in mind the footfall which the temple receives. But in the garb of the same, without initiating any proceedings as permissible in law, the government cannot make any construction over the land belonging to the school as well as the third party, including the road which is meant for commutation of the inhabitants or of the locality. The direction was passed upon the authorities to give response to the allegations made in the instant public interest litigation. And in compliance thereon, learned additional government pleader hands over the instruction received from the respective department, that is Tehsildar Baramba. Stop. The said instruction reveals that after the deployment of the armaments and the other officials belonging to the RI Sodar, the spot was visited, and it appears that the said temple building has been made by encroaching 15 kadi of land of the school boundary, that is plot number 20, and 5 kadi of the village road, that is plot number 314 under khata number 371/11 by some villages of the said that village. The report further indicated that immediately after noticing that the construction is made over the land belonging to the others, the steps for demolition thereof is undertaken. Semicolon. Even the fund to be allotted for such constructions have been kept in abeyance for the time being. The moment such report indicates that the construction has expanded over the other properties and is not restricted to the property belonging to the temple, and a decision has been taken for demolition of the area which transgress the territorial boundaries of the temple. There is no justification in keeping the public interest litigation pending. The relief claimed in the instant writ petition has been redressed on the stand of the government, communicated through an instruction filed today. However, the apprehension still continued in the mind of the petitioner that despite the decision having taken by the government to demolish the constructed portion, encroaching upon the land as indicated there, the authorities may sit tight over the matter. Stop. We appreciate the agony and the anguish of the petitioner, but the moment the government has identified, after extensive exercise of the survey having made through Amin and the other officials of the RI Sada, and found that the same has been made beyond the boundary limits of the temple, and a decision is taken to demolish, we expect that the authorities would take all reasonable steps as required. And shall remove the construction which is made over the area so identified by the army within the reasonable time. With such observations, the writ petition is.
And that's not only temple and community center both.
Everything is there. They have set upon.
No place.
Oh, it's called the list.
Item number 11.
Public interest litigation. Then that's what we have impugned is the proceedings in the public hearing under the environment impact assessment notification. Wherein, my lords, there are two grounds of challenge. The first, my lords,
there is no green tribunal here.
my lords, there is a green tribunal.
So why don't you flag an issue before the green tribunal
My lords,
relating to environment?
my humble submission is this honorable court can also entertain my lords public interest litigations pertaining to my lords environmental issues.
That's true. You can flag that issue there in the green tribunal relating to environment.
My submission is more on the procedural violations which has happened in the.
You can raise that. They can also take care of any statutory violation. Why bypassing the tribunal when you straight away come to the scope? You just go there and then come. And you want a public hearing.
No, there is
for the project.
No, the
Then
public.
in every decision which the government takes, you'll have to do a public hearing. There will be a mass. Let us go that far. There should be an election.
No, the public.
And the choice of the public will be taken every time when a decision is taken by the government for any policy decision that should pass the muster of the public.
Well, the public hearing is as
Where we, which you have made.
the public hearing is as prescribed under the EIA notification. I have put that notification. It is mandatory.
No, it's not.
The public hearing is
The
mandatory.
public hearing is the statute.
May I take my lords to the statute, my lords, the notification.
Is what you say, madam. You have to respond to it, including the maintainability.
My first submission is that the notice has to go to State Pollution Control Board also, and the private respondents.
So they have to take a decision.
Minutes, the proceedings of public hearing is attached in the writ petition only, minutes. And in the proceedings, all details are mentioned. Annexure 1, minutes, page 29. And at page number 29, the statement of issues and the response of the project proponent is also mentioned, minutes.
What decision has been taken?
So, with respect to what decision had been taken thereafter, there is nothing on the record, madam. That we take instructions. The public hearing recordings are there.
Yes, that I find.
Yes, madam.
That I find that it ended with the thanks to the chair. Then what decision, what resolution, nothing has been.
No, because this matter is listed for the first time, madam.
Maharaj, if I may, as the process is, Maharaj, the public hearing takes place, and then the decision that is passed in the public hearing or the resolution that is passed before the public in the public hearing, that is
Where is that resolution?
Maharaj, the proceeding
is not in a position to say that what resolution has been passed, whether the grievances of the public has been taken care of.
Whereas my submission here is that I was not, Millards, the affected villagers were not, Millards, allowed to participate in the.
What is the modalities or the methodology which is to be adopted for public hearing?
Please,
Every individual has to be given a notice and then to be called.
There is a public notice which has to be given.
So
the public notice, Millards, the statute says that a minimum 30 days have to be given. In this particular case, the public notice is given on 3rd of January for a hearing on 18th of January. So that minimum 30 days.
Where is the mandate that it has to be given?
My lords will find the mandate, my lords, page 90.
Yes, which one? Public consultation.
Public consultation.
That is a different one.
No, my lords, this public consultation is the public hearing.
Where is the mandate of 30 days?
Please, Millards.
I just wanted to know.
Yes, the mandate of 30 days. My lords may turn to my lords may see page 90.
90.
90. My lords, I'll read, my lords, stage 3. Stage 3, public consultation. Seal number 1. Public consultation refers to the process by which the concerns of local.
No, I'm just talking about the 30
yes,
days
my lord. That my lords will find it page 124, which is appendix 4.
What really I know.
Appendix 4.
You are raising an issue that it was not done 30 days. Let us see that.
Appendix 4, it starts at 124. My lords may turn to page 125. Para 3.1, my lords. If I may read. Notice of public hearing. The member secretary of the concerned SPCB or UTPCC shall finalize the date, time, and exact venue for the conduct of public hearing within 7 days of the date of receipt of the draft environmental impact assessment report from the project proponent and advertise the same in one major national day.
Oh, I got it. Minimum notice period of 30
minimum
days
notice period of 30 days shall
for publishing the response.
Please, Millards. Now, Millards.
So no, it
page
was
51, Millards, is the notice.
Say it is short of.
Please, Millards. It's short of 15 days, Millards. So what, Millards, it defeats the purpose of wide consultation because I have to be given a minimum 30 days. That is what the statute mandates. Page 51, Millards.
Yes, madam. Give a response to it.
Well, it's state pollution control board notice as to which state pollution control. Notice has to go to state pollution.
Have you issued a notice on the pollution control board?
Yes, yes, the pollution control board is opposite party number 6.
Have you given a notice?
I have not given, because the notice was not issued.
Notice to be given.
And when that's the union.
And keeping the point of maintainability of the instant public interest litigation open. Yes.
Union of India, Mr.
Union of India members.
Appearing.
Yes.
Because Union of India is the.
OP number 1, man.
Yes. So issue notice, returnable.
Madam, you are 2, 3, 4, 5.
No, it's 2, 3, 4, 5.
2, 3, 4.
State pollution control board is different. You have to take notice.
Different, they have a different. count.
Take out notice.
Messages.
6, 7. Notice to go.
7 is the project proper.
Adequate numbers of corpus.
Project proper. 7, OP number 7 is the project proponent, so they are a necessary.
Yes. File the requisites.
Please.
Yes.
Item number 12.
I have an interim prayer.
What?
I have an interim prayer.
Take notice, I also.
That stall the project.
No, not stall the project. This is at the stage of environmental clearance.
Whatever the decision is there, we will consider. We can't stall the project.
No, there is no stalling of project.
No, sorry, we can't. No, if you
I am
at
just
this stage,
seeking,
at this stage, if you keep it, then we'll have to go into the maintainability first. Come after that, we'll consider. Yes.
No. Notice and I also.
Notice. Agree.
Item number 12.
The Lordship matter termination of contract without following in natural justice, and the contract itself is borne out from a state policy and Lordship, and the petitioner was discharging its statutory obligation without following due procedure of law, Lordship, even if.
What is the procedure of law?
Lordship kindly state, Lordship kindly see the.
If you are a contractual appointee, and if they have terminated the contract without putting any stigma on you, well, are you required to be heard?
Lordship.
Natural justice. Show us one judgment.
Lordship, I'll show the judgment, Lordship, kindly.
Please.
I want to.
If he puts a stigma, something is put on your functioning or whatever, then you are entitled to a hearing. But when it is a simpliciter termination of a contract.
Lordship, kindly come to contact for a moment. Lordship, annexed to page 62, Lordship, for a moment.
Yes.
First paragraph, Lordship.
Yes.
Agreement between first party and second party.
For supply of the manpower in the production process and valid
Yes.
for 1 year.
The agreement will valid.
2025. No difficulty.
It is up to 7 June 2025.
Oh, no difficulty. It's a contract.
But Lordship, I am here. Lordship is not a general contract, Lordship. Here is a contract. I am, Lordship, complying the statutory obligations in view of the Contract Regulation Act, Lordship. Lordship, kindly for a moment, the order of Lordship, that is. Lordship, kindly come to page to annex 3, Lordship. Page 69, Lordship.
No difficulty.
Lordship, Lordship, when I'm.
What by all the provisions of the contract liberals?
Yes, Lordship. When I'm Lordship. So there is, when the contract itself fixes up, Lordship, any termination will prior to 1 month.
That the contract does not have a termination clause.
Yes, Lordship, kindly. Lordship, kindly.
It shows.
Lordship, kindly come page 67.
Yes.
Page 67, Lordship.
Yes.
Lordship, either party can terminate this agreement.
By 1 month notice
Lordship.
without assigning any reason.
Lordship. So at least 1 month notice required, Lordship.
No doubt.
But here, Lordship, kindly see what they have done. Without doing so,
Immediate effect.
Lordship.
With immediate effect.
Immediate effect, Lordship.
You pay them 1 year. That's all. 1 month.
Lordship.
The termination.
That is only my endeavor, Lordship.
Private respondents, my lords. The termination notice has been issued by the private respondent, my lords.
What private?
Bloomscraft Private Limited. It's an agreement with the private party. The petitioner has entered.
Who is he? I was thinking he's a Bloomcraft Private Limited.
Lordship.
He's a Bloomcraft.
No, my petitioner is
Mangala. Bloomcraft is the Lordship, my employer, Lordship.
Oh,
But Lordship, they are
thought that Bloomcraft, who has come before me.
No, Lordship.
As I do not see the cost title, that's why.
But Lordship, here, Lordship, I am discharging public duties. It is not a private contract, Lordship. It is born out from the state policy. Lordship, can you come to Annex 1? Lordship, can you hear the state policy? I am not discharging ordinary public contract, Lordship. It is born out from the state policy. And Lordship, this is supervised and Lordship, entire monitored by the state government. So I am discharging public duties. It is not a private contract, Lordship. Lordship, because Lordship, kindly come to Lordship page 23. They have come up with a policy, page 23. The guidelines seek to improve the efficiency process associated with the manufacture, import,
Sir,
export.
your grievance is against a private individual.
But my
arising out of a contract. How you can robe in the public
But my
element?
humble submission, I am discharging public duties. It is not ordinary public contract, Lordship. Here, Lordship, I am
Then I remind you of two judgments of the Supreme Court on this point.
I have also number of judgments, Lordship.
Two judgments of the latest judgment of one
But here, Lordship, only I can convince.
Army Educational Institute. Please read that. And the earlier one is
I'll go through. Lordship.
Saint Mary's Institute.
In service matter.
There, when you talk about the public element and the public duty,
Lordship.
so these two judgments have taken
I'll
care
go.
of.
I'll
Please read.
Lordship.
Saint Mary's must be of 2022 and Army is of 2024 judgment of the Supreme Court.
Lordship. Go through.
It says that distinction has to be drawn between a public element and the public duty and the duties attributable on the basis of a contract.
I will examine, Lordship.
Question that educational institutions are discharging the public duties. That has the element of a public involved in it. And therefore, anything which is done in respect of the same is amenable to Article 226 of the Constitution.
Yes.
Public duties and public elements. There the question was that school is one side and his employees are another side. Similar analogy if you draw. Then in that event, if there is anything done to the employee, then the employee who must be imparting education, but his rights emanates from a public law, a private law. It does not involve any public element.
Yes.
Here, the Bloomcraft has entered into an agreement with them for rendering or for providing a manpower or man resources.
Lordship.
They had entered into a contract with you,
Lordship.
subcontract,
Lordship.
to provide the manpower. Now the Bloom has terminated the contract.
Lordship.
Then it will be under the private law. It does not have a public element into it.
I can convince, Lordship.
Read those judgment and then convince.
Lordship. But I have
the very fine distinction is made
Lordship.
that which will come under the public law forum and which will be under the private.
I go through. I think, Lordship, I can convince, Lordship, because I'm coming.
Go through it without reading. Don't be so confident
Lordship,
that you will be able to convince. Please go through that judgment.
Yes, Lordship, I'll go through.
Please.
Both the judgments, Lordship.
Saint Mary
and Lordship.
and
Army.
the Army educational or something. Now everybody has a gadgets now.
That's only one submission here.
Can you find out this Saint Mary? One is by Justice Rishikesh Roy, if I believe. Saint Mary is by Justice Roy.
And according to one of the decision-based judgments.
August 22, perhaps.
Told that 2020.
Saint Mary Education Society versus Rajendra Prasad.
Correct. And this is by Justice Rishikesh Roy, if I correctly remember. Authored by him.
Honorable Justice D.Y. Chandrachud and S. Panna.
Who has authored? Then the army must have been authored by Justice Roy, if my memory goes right.
Justice Party or
Justice Particular, army.
No, this is Saint Mary's.
Saint Mary's. And the army.
Saint Mary's are Justice Anuruddha Ghosh and HON'BLE.
Okay.
I'll go.
Then
I'll
my
go.
memory is betraying me.
That's only one solution. Here, the agreement is executed between two private parties.
Oh, madam, why I said those judgments? Please. In that judgment, it says that it is a private contract between an educational institution and its employee. It has got no public element to come. Similarly, if he is, the contract is with the subcontractor. So it is a matter between a contractor and a subcontractor. Maybe the contractor is discharging those duties by providing a manpass is one thing that will come under the public duties. But this kind of a relationship is under the private realm of law. This is what I wanted to make a distinction. So the writ is not maintainable. There it is held that the writ petition is not maintainable under Article 226.
That principle I have applied in one of the division bench.
Then I have
That is,
but I want to develop in my case lordship, because here lordship, that's what lordship, that
but
the agreement between two private.
Christian Education Board case.
But here lordship.
Christ Collegiate School.
My difficulty is again before these two judgments, my own judgment will stare at your face.
Army Warfare Education Society
Correct.
is of 9th July 2024.
Said one is of 22 and one is of 24.
I will examine lordship all the judgments and I will.
Prior there to my own judgment
Yes, I will
in
show.
Narayana school. Prior to these two judgments.
Judgments, I will also.
You have to also consider this Ramakrishna Mission's judgment of the Supreme Court.
Lordship.
Come, read it and then convince me.
Lordship.
Okay. When?
Lordship, because lordship, in fact, difficult lordship.
So tell me now the ball is in your court. You tell me what time you require for your preparation.
Lordship, let it to next week lordship, so that before.
Anytime you just suggest, no difficulty. Yes. But satisfy on that.
Let's try.
Convince me.
I'll convince.
Next week?
Next.
Which one?
13th.
I'm operating lordship.
13th?
13th, 1-3.
1-3. Yes.
14, 13, not a good day. 14. Lordship 14, let it go on Wednesday. Lordship.
Yes.
Item number 13.
I'm containing them. I'm operating this.
Here the matter relating to limited of 180 ml of liquor.
Oh.
So today, a lordship had fixed all the matters today. And when a direction was given to state council to file their company, one cases the lordship had directed 5,000. Now they have not come up with a response.
Oh.
So here, madam, the order was there. Till today, lordship enhance it.
Item number 38 is not marked to me, my lords. But that's matter.
What? Have you filed your response? He said.
I have to check with the council who has been.
So let this matter be taken up along with which one?
Item number 38.
38. Just wait. I'll take up this matter along with 38.
Madam. 13, 14 and 13. 14 also.
14 also. Yes. What's appearing in 14?
What's
Item number 15.
My lord. My lord, here, my lord, the government has decided for a construction of a Dola Mandap.
What?
Dola Mandap. Okay. That is milkman community. They are also celebrating that Dola festival. They congregated in one place. They are also celebrating that Dola festival in a pilgrim place. The government has decided to construct a Dola Mandap. That is also in the DT's place. But what happened, my lord? The DT place, the recorded land, now it is merged with the river. So that is no existence of that river. So now,
Existence of a river or non-existence of the land?
Non-existence of land now.
You say non-existence of a river.
No, no, sorry. Non-existence of the land.
Okay.
Now it has already been merged with the river.
Correct.
Sir, what happened? Now, erroneously, the plot has the private plot, that is Titivar land. That land has been decided to construct the that Dolamanda, because no government money can be also released in favor of a private land.
No. Titivan, the land.
Titivar means that is recorded in name of somebody.
Somebody else.
Yes.
So somebody else has any grievance.
No. Why should he will make sir grievance? Because
What?
the construction is going on, going to construct in his land.
So he's happy.
But because the entire the construction will be owned by him without giving a single paisa.
No. Why? It will remain utilized by the community.
No, wrongly, sir. Instead of constructing that building, that Dolamanda in a British land, now it is erroneously constructed in a private land.
Oh, sir, what do you think? I have not understood.
Sir.
I understood.
Sir.
You say that in the DT's land now it has submerged into a river.
Sir.
There is no existence of land.
Sir.
Now they have shifted to make a construction over an individual
not
property or property.
Sir. Not knowingly they have shifted. Erroneously they have shifted. No, because there is also a video.
Illegally, let us go.
Yes, sir.
Illegally they have.
Sir.
Erroneously is also a very mild word for you.
Sir.
I'm giving you a harsher word.
Sir.
Illegally.
Sir.
Now question is that the land over which they wanted to make a construction.
Sir.
The owner of the land has not come up.
Sir.
Correct?
Yes.
Now, the bottom line of the entire story is that even if they construct over a private land,
sir,
and if the owner of the land does not raise any objection, it does not mean that the purpose and object of that particular, the manda will be lost.
That cannot be used by the public, sir.
Utilized by the community.
No, that cannot be used by the public because because they are private land, because this is private citizen land, sir. The Sarpanch also, sir, by the Annex of 7, sir.
Sir, who can prevent? Who can resist not for utilization? The owner of the land over which this owner of the land is not raising any objection.
No. Sir, once any government money released in favor of a private person, he has to execute.
He is not releasing. It's a government who is making a construction over the land.
Sir,
must be the government must have taken some kind of a permission from the owner, either by way of police, by way of something else. We do not know.
Sir, no, sir. Once a government money is disbursed in a private land, he should execute that land, the sale deed in favor of the government.
Interesting. Then I say, there are many. Let us see.
Sir.
Not here. I do not know.
Okay.
In another state,
sir,
there is no land which is provided to the government, but still the court buildings are run from a rental premises.
Sir.
That means the government is really making money or spending money on the infrastructure of the court.
Sir.
Over the land, another individual.
Sir, here what happened?
Then every public must have the problems. It is the owner of the land who should have a problem.
Sir, because BDO receiving the objection, he has also requested the Tahsildar, sir. He has requested the Tahsildar for demarcation of the land.
You, whatever. Not what pending, but whatever. You take instruction. It's not what pending, but not what pending. Have you made the person whose land is taken as a partner?
No, I have not made.
Why you have not?
How can Sarpanch maintain?
His ROR is also annexed. The record of that.
Sarpanch has come.
File is filed by the Sarpanch, my lord.
Sarpanch can maintain.
Yes.
What is your locus standi to maintain a PIL?
Because basing on a public grievance.
No, as Sarpanch you are holding an office.
Sir.
Can you maintain a public
video, sir, Annex of 6, sir, page 22.
I am using a very proposition of law. You have come with the PIL.
Sir.
The first question is whether the Sarpanch can maintain a PIL. Tell me.
Because there is a public
show us one judgment that the Sarpanch can.
Can it be taken also next to Gal also? So
we have already Rosalind Pradhan case. Just last week.
Some cases, many cases, Sarpanch also filed many cases.
I am asking whether he can.
Sir,
we have held something else. So that's why we wanted.
I will satisfy my lord, taken up next week. Next week I will satisfy.
That apart a private person expressing no objection.
And why should he will raise an objection? Suppose any construction made in my land, why should I make an objection? Because I am the owner of that land. You cannot by making the construction, you cannot change my ownership.
How the
That is a
public example.
I think the debate is not going on.
Sir.
You both are answerable.
Sir, sorry, sir. Sorry.
There is another hall. I think the debate can be done. Very good. Why, sir? Only thing is we have decided in one case whether the Sarpanch can maintain a PI.
Sir.
We have raised issue. So
Before that,
only thing is that,
before that,
you are holding a
constitutional post. That is it. Sir, page 22, sir. Page 22. Page 22, that the Panchayat Samiti, the video requested the Tahsildar regarding the demarcation of land for a.
Sir, I understand you may have all the good grievances. Let us go, sir. Please try to understand in open mind.
Regarding mentality, that how this
as a Sarpanch.
Sir.
As an individual, I can understand.
Okay.
As a Sarpanch, still holding an office,
sir,
whether he can maintain a writ petition.
Sir.
Is it not ventilating his own grievance, which he could not succeed in a major democratic polity?
I love that.
It is to settle his own score because he was defeated by majority.
No, he is also functioning as Sarpanch.
You could not understand, sir. Sarpanch is an elected post by all the members of the Gram Panchayat or the Gram Panchayat Samiti. Correct? It does not mean that the Sarpanch is holding the majority. In some issues, he may be defeated by majority.
Sir.
If he is defeated by majority, can he come forward and score his own or settle his own scores? Because he is defeated by majority. PIR. That is what troubles
Sir.
So please satisfy
Sir. Taken up next week, sir.
On the prayer of the sir, next week.
18,389.
18389 of 2020.
What?
Yes.
Yes. Next week.
Item number 16.
I'm challenging the proceeding under section 74 of the GST Act and its combination in adjudication honor.
Why you have committed a fraud? Why have committed a fraud?
Yes, that's here, undisputedly the tax amount has been paid prior to the initiation of the proceeding. That's undisputed. Now he says that because of lack of reconciliation, he takes jurisdiction under section 74 and it will be noticed, and in the order he admits that tax has been paid and he goes on to levy penalty.
Where is the order?
Order under Annex 2, Miller. The operative person may kindly see page 59. It starts from 43, Miller. May kindly
Has he observed that
yes, he is admitted.
Prior to initiation,
yes,
you have deposited?
Yes, kindly see page 15.
Yes.
May place, Miller. I have verified the above certificate from so-and-so and found to be issued for the reason. From the above, it appears that the noticee has paid the GST of rupees
such on differential value of the royalty paid as ascertained by the investigating authority.
In so-and-so years. From the allegation framed in the so-called notice, it is also mentioned that due to non-submission of reconciliation statement of GST payment under the RCM reverse charge mechanism, GST payment made against the past liability has not been considered. Upon submission of the above certificate and subsequent verification with the GST returns available in the GST back office system.
So this is the total amount of
yes, this 1,11,00,000 is the
total amount of the GST liability.
Yes, madam. That liability has been discharged.
So they have not paid the interest. What delay?
But here my submission is that
imposition under section 50.
Yes, madam.
Interest. Yes.
So only for the purpose of interest, whether a 74(1) proceeding can be initiated, whether he can assume jurisdiction for initiating proceeding under 74, only when he admits that I paid the tax and interest has not been paid.
No, paid the tax within what time?
But prior to initiation of the proceeding.
is there any law that prior to initiation, if you make the payment, that would subserve the purpose, no interest would be levied? If you make a defaulting payment of the GST within the time limit.
Yes, interest would be levied. Right. If there is a delay in payment.
Correct.
But whether, can you see section 74? May I please? Where it appears to the proper officer that any tax has not been paid or sought paid or erroneously refunded or where the input tax credit has been wrongly availed or utilized by reason of fraud or any willful or suppression of facts to evade tax, he shall beg pardon.
Yes.
He shall serve notice on the person chargeable with tax which has not been so paid or which has been so sought paid or to whom the refund has been erroneously been made or who has wrongly availed or utilized the input tax credit, requiring him to show cause as to why he should not pay the amount specified in the notice along with the interest payable thereon under section 50 and a penalty. So the first requirement is
proper
that
officer you are not challenging.
Correct?
Proper officer's power you are not challenging.
Yes, I am telling you. He cannot
Proper officer.
He is a proper officer.
So lack of jurisdiction you are not challenging.
Jurisdiction is.
You are challenging jurisdictional fact.
Jurisdiction.
You are challenging jurisdictional fact, not the jurisdiction.
No, I am challenging the jurisdiction.
Jurisdictional fact. You are challenging the jurisdictional fact, not the lack of jurisdiction.
Exactly.
Irregular assumption of jurisdiction you are challenging.
Jurisdictional fact is there has to be a short payment of tax or non-payment of tax because of fraud and suppression. That's the jurisdictional fact upon satisfaction of which he can only assume jurisdiction under section 74 and issue me a notice. When without satisfaction of that, he cannot assume jurisdiction or the competence to issue me a section 74(1) notice. In this case, he has assumed that jurisdiction.
Then why don't you go and file an appeal before the appellate authority?
This is a question of law and
It's a question of law. So appellate authority is not competent to decide the question of law.
He can, but in view of the fact and situation, there is no disputed fact. There is no disputed fact. He has no competence to initiate the proceeding.
Go there.
Maybe referring to some of the decisions which says that when there is
show your bona fide of depositing 20% of the total amount, then we will consider it.
I am telling
you show deposit.
When I am challenging the very competence, nothing is payable, tax has been due.
I understand why you are heading here to avoid that particular stringent provision.
No, if I go in appeal, I don't have to pay tax also. No, since there is no tax.
Go there.
But here, kindly see. When he has
don't jump the forum. You go there.
Here,
don't jump the forum. Don't jump the forum. You go
here, there is no disputed question of fact, and the only question is.
Sir, 107 you are bypassing.
I am back.
That is the whole difficulty.
I'm just
you have not come at the right time. That is the whole difficulty, which the first appellate authority cannot do. Can under writ jurisdiction we can do.
Yes,
we can do. Where is that?
Maybe referring to some of the decisions. I'll just try to persuade you.
If there is an alternative remedy, we will not interfere.
There is an alternative. 107 is there.
So
my submission is there.
It's a discretion of the writ court.
It's
if the court refused to exercise discretion, we go there.
It's a discretion, no doubt, But here, my humble submission is that the discretion, may be exercised in view of the undisputed and the very complex. I'm referring to
then what is the purpose of incorporating the hierarchical system? Is no use, is a farcical. Then we'll say the legislative incompetence is visual, is well evident.
My lord, when in a fact situation, absolutely no jurisdiction to initiate this proceeding, and he takes up this proceeding, my lord. Then, my lord, my humble sense is that it's the only 226.
No. Show us. No assumption of jurisdiction. Then.
Should it
Kindly see paragraph 2. This application arises out of
Yes.
Haryana Value-Added Tax Act.
Yes.
Paragraph 2. Two questions emerge for decision in this appeal. First, whether the High Court was justified in declining interference on the ground of availability of alternative remedy of appeal to the appellant under Section 33 of the VAT Act. Now, kindly see paragraph 3. What was the contention raised before the High Court? It appears in a perusal of the order under challenge in this appeal that the appellant had questioned the jurisdiction of the Deputy Excise and Taxation Commissioner from Revisional Authority to reopen the proceeding in exercise of suo motu revision order conferred under Section 34 of the VAT Act and to pass final orders, holding that the two assessment orders, both dated so and so, for the year so and so, suffered from illegality and impropriety as delineated therein. Now, kindly see the last 4 lines of that paragraph. I'm just seeing the last 11 paragraph. Last 4 lines of that paragraph. After referring to the Titlagate, based on which it was contended on behalf that where any right or liberty arises under a particular act, then the remedy available under the act has to be upheld. The High Court was of the opinion that there can be no presumption that the appellate authority would not grant relief sought for in the writ petition. Hence, the writ petition was dismissed and the appellants were relegated to the appellate remedy. Now, kindly see what was the observation of the Honorable Supreme Court.
There, that was relating to classification of commodity, less payment of tax. But when you yourself have detected the tax wrongly claimed, you yourself, then you paid the tax without the interest. Then what is your intention? Can you regularize? Can you say that tax is regularized? After you yourself have detected the element of tax which you have wrongly claimed.
No, I'm not here. It's not a case of ITC. It's not. It's relating to payment of GST on the royalty that I have paid to the government. Now, you also know the royalty is because the challenge are pending. It is. Now, kindly see paragraph 8. Kindly see paragraph 8. It starts with that apart. I may read the last 4 lines of that paragraph 8. In the decision, this court found the issue raised by the appellant to be pristinely legal, requiring determination by the High Court without putting the appellant through the mill of statutory appeals in the hierarchy. What follows from the said decision is that where the controversy is purely a legal one and it does not involve disputed questions of fact, but only questions of law, then it should be decided by the High Court instead of dismissing the petition on the ground of an alternative remedy being available. Now, reverting to the facts of this appeal, we find that the appellant had claimed before the High Court that the suo motu revisional power could not have been exercised by the revisional authority in view of the existing facts and circumstances, leading to the only conclusion that the assessment orders were legally correct and that the final orders impugned in the writ petition were passed upon assuming a jurisdiction which the revisional authority did not possess. In fine, the orders impugned were passed wholly without jurisdiction, since a jurisdictional issue was raised by the appellant in the writ petition questioning the very competence of the revisional authority to exercise the suo motu power. Being a pure question of law, we are of the considered view that the plea raised in the writ petition did deserve a consideration on merits, and the appellant's writ petition ought not to have been thrown out at the threshold. Now, in paragraph 11, again after referring to various decisions, the last 2 lines I'm placing, paragraph 11, as noted above, the very jurisdiction of the revisional authority having been questioned in the writ petition, the impugned orders of the High Court dismissing the writ petition without examining the merits of the challenge cannot be sustained, even if the High Court were to rely on that Titlagate paper mills case to support such order. The High Court, by dismissing the writ petition, committed a manifest error of law for which the order under challenge is unsustainable. The same accordingly set aside. Now, following this decision of the Honorable Apex Court, again, in 2023, this has again been reiterated.
This also mentioned that the PC has accepted their fault and paid the demanded GST liability through GST and so return for the subsequent period. Accordingly, the notice is found to have suppressed effects from the department and contravene the various provisions of GST and such and such with an intention to investigate.
Yes, did my present case. May I just be permitted 2 minutes to persuade your lordship? For the assessing authority has did, I have disclosed in my PL account the royalty I have paid to the government. Now that disclosure has been made. He takes up in from my PL account, and when I in reply to that during the investigation stage is that I discharged the GST on that. He says that no, it has been not reconciled. And in the so cause notice, by putting that verbatim the wordings of section 74, there is a suppression. He takes up, he assumes the jurisdiction to initiate this proceeding under section 74. And in the order itself, he reflects that yes, it has been paid. Yes. So when the assessing authority proper officer himself admits that the tax has been paid, my submission is that he has no competence to initiate the section 74(1) proceeding. There is a complete lack of jurisdictional facts, my lord. So, my lord, I humbly pray that your lordship may exercise the jurisdiction of deciding the issue. Judgment, my lord, following the judgment which I have shown, from the latest judgment. Yes. And also have annexed the circulars issued by the government following the judgments of the Honorable Supreme Court, how or in which cases he can initiate the procedure under section 74. That circular also is just violated. That circular also has this. And this which language Annexure 3, the circular issued following the judgments of the Honorable Supreme Court. Malad, kindly just 2 sentences from the circular. Malad. Annexure 3, page 63. To my writ application. May I place me?
Sir,
Annexure
sir,
3.
there, it is within the discretion of the authority under section 74 to conclude the proceeding and drop the proceeding if certain payments are made. Now, you are citing a judgment of the Supreme Court. Have you noticed that what was the subject matter of dispute there? This judgment. In this judgment, the High Court, in unequivocal terms, says that when there is a provision for an appeal under the statute, then the writ petition is not maintainable. The Supreme Court took up that particular expression, not maintainable, under a serious note and says that Article 226 comes within the basic structure of the Constitution, cannot be undermined. Nobody can say that the writ petition is not maintainable because of the alternative remedy. And the court has proceeded on that basis. No, it should not. You should not say that it is not maintainable. At one, we are also at one. There are distinctions between a maintainability of the writ petition and entertainability of the writ petition. We may refuse to entertain the writ petition on the count of an alternative remedy, but we cannot say it is not maintainable. Maintainability is still there. Second, when you say the pure question of law, where the Supreme Court has said that if the question of law is a pure one, does not require any kind of a discretion, any kind of a laxity, any kind of a determination to be done, and purely on the basis of the interpretation, then the High Court should not exonerate from deciding that pure question of law. Here is a question which comes under section 74. 74 has a very unique language. Language is evasion of payment of tax. It is a subjective matter. A person has an intention to evade the tax or does not have an intention to evade the tax is a more relative in nature, and one has to decide on the basis of the conduct the person who has approached before the court. And the second important factor is that outcome of a fraud in section 74. Fraud is also a mixed question of fact and law. So in that event, if the authority has to look into various other documents in order to ascertain that whether there was any intention to evade the tax, and it is a fraudulent intention that is come, then in that event, the authorities can. They have specified the quantum. Section 50 talks about the statutory interest to be paid in case the payment of tax is not made within the time frame. Automatically. Penalty as specified in the notice, which may be equivalent to the amount of tax. It may be less than an amount of tax.
I just want to
even subsection 5 or 6 says that if he pays 25%, he may proceedings and then will not proceed on that basis. This kind of a discretion is vested with the authorities. Then what the High Court will do?
What has fallen from your lordship is absolutely right, madam. In the present case, madam, when a dealer prior to initiation of the proceeding has already paid the tax, can under any circumstances the dealer have an intention to evade the tax?
Oh, definitely. The first thing is that it is a fiscal statute. Yes, if there is a timeline given for payment of tax, yes, if you do not make the payment within the time,
yes, and
then you, of your sweet will, you make the payment after 3 months. It may be the authority has noticed it, did not issue any notice on you or initiate a proceeding, but you have made the payment voluntarily. Yes, there was a default. For this 3 period of defaults, will you get a moratorium? Will you be blessed with the inaction on the part of the authority not initiating the proceeding? Then what is the meaning of the word? We have to, where it appears to the proper officer that any tax has not been paid.
Yes,
what does it mean by this expression? Has not been paid. Means payment of tax within the time set forth in the act for its payment.
Kindly read whether any failed, not paid the tax by reason of fraud. Kindly, it has to be read conjointly because.
So that's why I say it's a more a subjective matter, which has to be decided.
But in the present
on the basis of the facts, the intention has to be culled out from the facts which is pleaded before the
But
authority.
what's prior to initiation of the proceeding if the tax has been paid?
Sir, that is why one has to interpret the word that where it appears to the proper officer that tax has not been paid. Now, this expression means that prior to the initiation of the notice, the tax is not paid, or it has to be interpreted that the tax which is liable, which is required to be paid within, say, 31st of January, has not been paid within 31st of January. Let us see. There is a time limit within which the payment has to be made. I believe so. Under any fiscal statute.
Kindly see here, in this
I'm
case,
asking you.
Yes, Malad. Here in this case, the substance of the tax is the royalty which I paid to the. That's the incidence
It's a fixed question of fact.
It's all admitted, Malad. Kindly see. The royalty has been disclosed in my PL account. He takes up that amount. There is no dispute over what I have disclosed in my PL account. So can there be in any case, Malad, it's a case, can be a case of fraud or collusion, Malad?
Oh.
When I have disclosed it in my PL account, before initiation of the proceeding, I have paid the tax. Now, there is section 73, Malad, kindly see, section 73 and 74. 73 is.
Oh, it does not talk about the fraud, and 74 talks about the fraud. I understand the distinction.
So, Malad, at the very initiation of the proceeding.
Again, I'm saying it's a matter of fact and a law.
My humble submission would be this.
Sorry, we can't.
My humble submission would be this.
Brother,
to conclude, Malad, may I submit this? To conclude.
No, sir. I think we have given you enough opportunity to argue
for that.
And it's better to go there.
If I just would take one more sentence, in the present case, apart from this also, there is about 5 years have been clubbed together. And this issue has attained your lordship attention in many cases, Malad.
That you place that case first. Yes, how can you do it? Now, this is the point where we can.
When this honorable court has
because it goes into the root. Yes, sir. How can you?
Sorry,
Peter, this is the good point. This is a good point.
Yes.
So,
Alpha blood, all the cases not there.
When the other cases are there, why you wasted so much of time? I not say wasted, persuaded by investing so much of time. Is the next date?
Not coming.
10th April last.
Make a necessary changes here. Making a necessary changes. When is the other matters coming?
Today is not today is also there. Item 34. Some cases we have not
many other provisions also. Provisions.
Make a necessary changes and the matter is appearing.
But today we are for some cases we have not filed done, so we can keep it up.
So we are keeping it after vacation.
Yes, all the cases also keep it.
We'll come there.
I'm just making
1 week after
I'm just submitting
Make a necessary.
What is that case? Lalsan Jewelers.
Which one?
Lalsan Jewelers.
No.
Multiple tax periods.
So it is already given. The judgment.
VAT regime. Under VAT, you are the additional standing counsel then.
Yes.
You are additional standing counsel then.
Yes.
Just a man is sitting there.
Yes. For the next problem.
Item 17.
Yes.
17.
I challenge the annexure 5 your lordships, page 89 your lordships.
Yes. You are in serial number 8.
Annexure of page 89 your lordships.
You are serial number 8 of that block.
Yes, madam.
Serial number 8.
Let me read.
Are you Mrs.
Yes, madam. It's serial number 8, madam.
Serial number 8.
Madam.
Yes.
My lord, we challenge the to the order, your lordships, the common keep to order, your lordships, wherein the appeal file the revenue has been allowed by non-speaking order without considering the merit of the case and on violative of the principles of natural defense. My lord, the background of the case is, lordship, that the petitioner is a supplier of provider of service of export services in lordship.
But you did not appear there.
My lords, I have not given sufficient opportunity for appearance, your lordships. Can have the glance. The appeal has been filed. The copy of the appeal has not been.
They were given. You were given an opportunity of personal hearing, but you did not turn up.
My lord, can I have the glance to page 13, your lordship, 13, your lordships. 13, my lord.
You have done. Since they did not appear, so allowed. Not a single word is given on the merit. Why the exemption cannot be extended, allowed, something, nothing. Simply say that opportunity was given to him to come and make a personal or a hearing. They did not avail, so I am allowing all the appeal. I have not come across this order in my career over there and here. I never come across. It says, in such scenario, I do not find any merit in keeping the appeals pending because they are not appearing. And I am of the view that the duty demanded along with the interest in review is to be covered from the respondent quantum dividend. That's all. And accordingly, all 11 are allowed. No reason. Assessing officer must have passed an order in their favor. The department has gone for an appeal. Will not the appellate authority record the submission of the department, consider the law, consider the provisions, the facts of all the cases, and also, sir, it raises a doubt that 11 matters were taken up together. None of them appeared. Is it believable? At least one will appear.
Nobody has appeared.
Or it is believable in a common parlance. Out of 11, at least one could have come.
If your lordship will see page
all are defaulted.
101, your lordship kindly have a glance.
No, what is this review order? What is this meaning of review order?
Petition order passed against the department, then a review has been conducted and then decided.
Will you not record the reason?
Yes,
show me where is the reason.
Your lordship is absolutely correct. I am also your lordship. I am also your lordship. Without recording my comment.
Nothing has been stated. 5 paragraphs are dedicated.
Yes,
they were given an opportunity. They did not appear. They did not find response. Everything 5 paragraphs he did. Come to the conclusion.
Absolutely. Lord, therefore, we humbly submit, Lord, your lordship given an opportunity to appear before and lordship give a timeline so that order can be passed without recording my consent, lordship. I will not conscious of that and I should accept it view that I am your lordship with your lordship.
Brother, I have dictated many orders on non-speaking.
Today disposal.
Legal appearance can be excluded.
They are agreeable, sir. They have written in so many words.
So far as your case is concerned.
No,
all 11.
Yes.
All 11 you have filed.
10. And with respective counsel, I will give the name. So far all this.
I told you.
ଦିଅନ୍ତୁ।
ଆପଣ ସବୁଥିରେ
Yes.
Item 18.
Item 18, your lordships, is a cancellation matter covered under the lordship's form.
Non-fighting. Yes.
Yes.
Item 19.
May I please? I had challenged the order of assessment on two grounds, non-compliance of the.
Oh, you have switched over the plan.
Yes, please. So here, your lordship has already come across the 2 to 3 cases that 7 days which been contemplated is section 144 B has not been complied with. Instead of that, my lord, even then, my lord, I have filed some document prior to assessment, I have not been considered. The lordship kindly see 144 capital B for a moment. And this court has already passed the order, and your lordship, Calcutta High Court also passed this.
(144)?
144 capital B subsection 6 Lord XI. 144 capital B subsection 6. Then lordship keep and XI.
This is Roman 11.
So, yes,
XI.
yes. The principal chief commissioner or the principal director in the art case may
144B.
Yes, your lordship. 144.
Where the SSE fails, where you are reading.
Lord, faceless assessment. 144 capital B.
Not standing anything contained in any.
Your lordship, that is not required in this case. Your lordship speak that kindly see subclause 6 for purpose of faceless assessment.
Subclause
6 for purpose of faceless assessment.
Where do I get it? I am not getting it.
Yeah. Subsection 1.
Subsection 1, 144 capital B, subsection 1.
Yes.
What?
Then we got subsection 6.
6 is so. 4.
Where a request.
For purpose of faceless assessment.
Faceless assessment.
Subclause 6 is the broader heading is
Subclause.
subclause. 144 capital B, subclause 6.
For the purpose, yes, for the purpose of faceless assessment.
Then you'll also keep it. Then XI.
The principal chief commissioner.
Yes, the principal chief commissioner or the principal director general, as case may be, in charge of a national faceless assessment center shall, in proper approval of the board, this conduct procedure for purpose effective function of the national faceless assessment center and unit set up in an automated mechanized environment.
Correct.
Now, let's see, I am enclosing the faceless assessment scheme incorporated in kindly see page 62. Page your lordship see 72. Process of assessment. In. In 1.3. Page 73 of my brief.
M point.
In 1.3.
Drafting details reference based on submission of SSC and materials on record.
No, your lordship, I may be.
Page 72.
72 is last, lordship. Process of assessment.
Following process is to be followed, M1. Which one you are referring? Page 72,
I'm referring to page 72. 72 last, in process of assessment.
Oh, process of, yes.
Then your lordships keep it, and then your next phase, aim 1.3.
Yes.
To ensure the adherence of principle of natural justice and reasonable opportunity to assessee, timeline to give obtaining response, this so-called notice shall be response time is 7 days from the so-called notice. Then your lordship see the so-called notice I have enclosed, page 91.
Each
91 of my brief.
okay.
Lord, in the first lines, lordship see, this is assessment of 23-24. And the date is Lord 26/2/2025.
Right.
My lordships keep all these things, Lord, kindly see page 95. In the last line, Lord, kindly submit
your response by
1/3/2025. This beyond Lord is not cover 7 days. Now your lordships will further, Lord, even Lord, I have not allowed 7 days. I have filed the document, Lord. The document which was filed prior to assessment, that even Lord not considered. Your lordship see the assessment order. There is no variation, there is no escape assessment, nothing. Lord. Your lordship will
which one?
kindly similar assessment order, your lordship.
Which one?
And demand is not close.
Where?
Your lordship see, Lord.
Annexure.
Annexure 1, running page 30, Lord.
Annexure 1.
Yes, annexure 1.
30.
Start from 25. Lordship kindly see page 30.
Yes.
Lord, it is seen from the SSC, all these documents we are disallowed, non-filing of the document. All this, Milord, 4 column has been referred into. All, Milord, is non-filing of the document.
Where? I do.
Page 30. Page 30.
Page 30 is subpara.
Subpara, Milord. Start from is seen, the SSC has given bill in respect of so.
Is 30.
Yes, up by brief.
304, 4.1.
4.1
is the beginning. Then subpara. Subpara.
It is seen that the SSC has given bills.
Yes. Milord's only demand is raised, Milord, non-submission of the document which has not been adequately allowed me to submit.
No, he has said that it is seen the SSC has given bills.
Yes.
In respect of a purchase of the raw material to the extent of such and such.
Yes.
And remaining unexplained purchase amount of rupees is being added to the total sum of the SSC.
That I could not have filed because of the capacity of tax.
Then what is not considered?
Yes, that is what we are kindly see. Milord, page 135, annexure 7.
Or from the order, it does not appear that.
No, he has not considered, Milord. Though he has filed the order in 18/3/2025. I have filed document prior to that 14/3/25. That has Milord not considered. So, Milord, he has not complied the Milord procedure of assessment, not 7 days. Even then, Milord, portal was open.
Beyond the notice period, you have furnished the document.
Yes, Milord. I have tried my level best. Milord, so one go, Milord, 58 GB can be uploaded. And it is used, Milord, 100 crores of turnover. How can I, Milord, upload it in a short time, Milord, 4 to 5 days? Therefore, Milord, the SOP has been considered by the board that give at least 7 days time. So he, Milord, allowed me 4 days. In this honorable court has, Milord, I set aside 1 and 2 judgment order C on the same issue, Milord. Same issue. Lordship C. This Calcutta High Court also, Milord, considered the SOP in case of, Milord, in 2 cases, Lordship C. And other High Court also, Milord, considered that. Bombay High Court also considered that 7 days is a mandatory compliance of 144 capital B. Even Milord, I am not asking anything. I am only, Milord, 7 days time. I should upload further document, let them pass out. I am not washing or something like that. I am concerned, Milord. I am only file the document that can be considered and pass a region order. And with the order, Milord, they are not been stay anything where that has been not held that. And first show cause notice that in category stated that 8% profit has to be determined. But when they pass the order, 10.58 without any further show cause. Show cause the first leave of the assessment proceeding. Lord. There is a raw copy. You'll see kindly raw copy. Say change. It changes the raw copy. So.
Talk about that if it is short of 7 days, then
yes, that is what Sri Gopal. Gopal story also. That is not that is confined to SOP and the form which has been not considered. And there is saved lot the 144 capital B and the SOP has to be considered so far as Calcutta High Court judgment is concerned. But here this Sri Gopal
that's that Calcutta High Court says that there was a violation of principle of natural justice because only all the major paragraphs were the reproduction of the so-called notice.
Yes.
And only 2 paragraphs were invested for the reply given by the SSC.
Yes.
And
no, your lordship, see the paragraph not quoted by my lord page, second page. Response time of 7 days may be curtailed, keeping in view that limitation date of completing the assessment. Hence,
where it is said in
the Sri Gopal. WPC number 18079.
Now the 7 days time, you uploaded all the papers or you could not upload all the papers?
I uploaded some paper within time, and thereafter I uploaded some document. Before passing the order of assessment, they didn't consider all document.
Even though Annexure 7.
Yes, your lordship. Suppose
Annexure 7 is your documents which you have uploaded.
Already uploaded prior to assessment.
On 14th,
yes.
The entire uploading was concluded.
Some part is there lacking because we are not able to. Your lordship, kindly imagine 100 crore turnover, and the document are only asking is invoices. That I filed audit report.
What it shows from what it falls from in 135.
Yes.
That table.
Yes.
Your submissions for 1/3/2025, 9/3/2025,
yes.
and finally on 1/3/2025.
Yes. 9 million they have considered. But why didn't consider? And
14.
Sorry.
14 he has not considered.
No. And one opportunity, 7 days, I can upload further document. One part of the document is there, some document I could not find. Because of the capacity of time and uploading 50 GB at a go, I can upload. And huge document, 100 crores account, kindly imagine, can I possible to each and every day I can upload it? And I have asked for the time. You'll actually I file a petition before this personal, kindly give us time. Even then,
yes.
Clear case of violation of situation.
And also page number 26. Final so-cause notice was issued on 26/2/2025.
7 days time.
7 days time was not given. After that, going for 7 days, in 2 cases, the document was uploaded, which has been accepted in the assessment order.
Sir,
only
you have passed the order on 18th.
18th, your lordship.
You have considered first. You have considered 9th.
9th.
Why you left 14th?
14th, lordship. What it may be happened that
Mr. Maybe happen. Why you have left 14th?
Lordship, in the time limit was of 1/3/2025. The 7 days.
Sir, 9th you have considered. You have extended time.
Yeah.
Yourself.
9th and 10th we have accepted. It is in
nothing is
first and 9th.
Even
first and 9th you have accepted.
10. It has been written. First to 10. The lordship.
10 I have mentioned,
9th
10 I have not filed anything.
At 10th you have filed? No, 9. At 108 page. Yes, yes, 108 page. It is 10, and see.
Sir, come to page 135, sir.
Only lordship.
Sir, come to page 135.
14/3/2025. Document has not been considered in this assessment order.
Why? That is the
Lordship, the order has been passed on 18/3/2025.
You have referred.
Much prior to that, will you not, when you permitted, your system permitted those documents to be uploaded, will you not take into consideration? And that was 4 days before that.
Let the lordship, they may consider this document.
Let them pass those documents and pass it for sure. Yes.
Further 7 days may be allowed so that I can upload it for this. That was a precaution.
And no adjournment.
No adjournment, nothing, my lord. Everything is ready, my lord. I am not quashing or anything.
No, even you, they were decided within 7 days thereafter.
Yes, your lordship. That is what my submission. Sole and substance, my lord.
Mr. Satpathy, page numbers, please. You refer to page numbers. जो पेज को हमको नले से पेज उड़ा कर
I kindly see, my lord, the
page 135 बता रहे
135 and SOP.
SOP कितने page?
We start from page 62.
62.
Yes.
Next.
Next 135.
35.
And then the assessment order is not a speaking order. Your lordship see, lord, the
page 1. Sorry, annexure 1.
Annexure 1. My lord, it starts from page 29.
25.
Sorry, 29 to 30, 31. No reason, nothing. Lord, what happened? Nothing. Simply say, my lord, it is added back.
1st March and 9th March considered.
In rest are not considered.
Yes. Yes.
Item 20.
Cancellation. Yeah. 21 same. The connected matter same.
Published matter.
20 both the cases.
21.
Sorry, 20 both the cases.
Both the cases.
Mr. Samal.
Both cases. 21.
21.
Item 21.
Similar to today's serial number 45 also. And bunch of matters 73 4B.
So this is what you wanted some time because
we'll take after vacation.
Yes. Date for conventions. After vacation.
Right. Item 22.
Cancellation. Yeah. Who is for the others? Yes. Next.
Item 23.
In this case, the petitioner challenges the order of assessment. Yes, what has happened in this case?
What? Single notice, multiple.
No. This is a different matter, Milord. What has happened? The background of the case is, Milord, there was an audit. During the audit, the auditor found that one of the supplier, RC of one of the supplier was cancelled retrospectively. But at the time of the transaction and supply, his RC was valid. So the question before your lordship is that whether the ITC can be disallowed on the sole ground that the RC of the supplier was cancelled retrospectively, but at the time of the transaction, the RC was valid and all the invoices, e-way bill and all the relevant documents was already before the revenue authority. Without considering those materials, Milord, they have passed this
You don't
order.
have the reply.
Let me give instruction on this matter.
How can it be?
True,
It was valid during.
Yes, what happened, the SSC, retrospectively, his license was cancelled.
How can it be? Then at that point of time, he's a bona fide, the contractor or whatever he's a bona fide.
De facto.
He continued with the contract.
He find when there was
The
an
transaction
audit.
was valid at that point of time. If you give a retrospective operation, how they do come to know? Can you make them responsible for that?
One time we gave him.
It was valid at that relevant point of time.
Let me take.
Can you defend it? Can you defend your?
I was referring to section 65. When audits were taken over, they find out that RC was cancelled during that period. So the ITC should not
No,
be.
it was valid when the transaction was ensued.
I had to verify that one, if the license was, his license was valid or not.
Got it. Subsequently, you passed an order invalidating it from a retrospective date. How do they come to know of it? And why they should be responsible?
They are deriving Q from 16.
No, it cannot be. Yes.
My humble prayer.
Next week. 2 weeks. No, 2 weeks are छुट्टी है. या भीतर रिकवरी कर देगा.
ना करियो स्टे कर.
Will stay you.
I also have fighting, so I do consider.
That is the only aspect on which assessment is
Yes,
based on.
that is the sole ground on which they have disallowed the ITC and raised the demand. That is the sole ground.
You want to stay on the demand?
Yes, ma'am.
2 weeks after means
All the payment of I have.
It is submitted by a parties that the sole ground on which the assessment is based on is disallowance of claim of input tax credit by the petitioner on for the reason that the supplier's registration certificate has been cancelled with retrospective effect. It is submitted that during the period of transaction, the supplier's registration was valid. The question she posed is whether the retrospective cancellation will entail the recipient deprived of bona fide recipient. Will deprive the bona fide recipient from availing the benefit of input tax credit. Mr. Avinash Kedia seeks 2 weeks accommodation to file response. As an issue note that since he has appeared, no issue of notice. Adequate numbers of copies of petition disallowed within 3 working days. IA as an interim measure, no coercive action. B
That is a reason whether one can negate transactions which was
this court is of view that when the supplier's registration certificate is cancelled retrospectively and the same was valid during the period of transaction, the recipient, the input tax credit which the recipient has claimed would not be, should not have been disallowed, which fact was detected during the course of audit. as an interim measure, no coercive action be taken against the petitioner in respect of remand raised in the assessment order dated so and so by annexer. List this matter. So the main case like the list is
23rd June.
Yes.
23rd June.
With due humility, let's may I submit one more thing. That the supplier whose RC has been cancelled, he has also paid all the taxes. I have also paid all the taxes.
That you reserve
which
for-
reflects, yeah, that reflects in the order themselves.
Conserve your energy exhaust on 23rd. Yes.
For
Great.
orders item 24.
Condonation, sir, state.
State has filed 303 days.
Yes. What do you say, sir?
I filed my objection to that. And you must have
They filed their response, or they do not like to file their response. I mean, rejoinder too.
I've given the copy of the objection right after. And last Friday, Russia delivered a judgment, very long judgment. I couldn't able to get it because it has not been uploaded. State appeal has been dismissed on the ground of limitations. That's why I've referred to various judgments, sir, including the judgment of your Russia predecessors. Where there is a delay also, so 500 some odd days.
Where is which application is the?
That
The number is
Subbaredi case was referred to. That is already uploaded, sir.
Writ appeal number 806 of 2024 on Friday.
I think that is already.
I was trying to find out that judgment today's morning.
What is this IA, which is a condonation? Which IA is
439.
2.436 up to 2024.
Para 2 to onwards. And the judgment was passed on 1/6/2023. Direction was made that to comply with the order within a period of 3 months. Then paragraph 3 they starts. They say that and they are the employees of the university. Right from para 3, you got to see judgment was.
Are you serious in opposing?
I am serious because of your lordships let down the law.
No, that is that was a different score. Here we find some distinction. If you read the whole of the paragraph, so far as conduct or the role is
That
concerned,
exactly I was showing you.
here conduct or the role was concerned, there was no negligence on their part.
You also see the negligence.
The negligence started the moment the file reached here in the
office of the Advocate General. I am showing that.
And now from there it is started. So the whose latches one can say. Then I am reminded of 81 Supreme Court. AIR 1981 Supreme Court. The Supreme Court has said that for the laches, negligence, carelessness of a lawyer, a litigant should not suffer.
This is not a carelessness of lawyers. I'll show you lots of
Three consecutive consultation at a considerable period of time. Just imagine why should have been done on a day-to-day basis.
But I fail to understand. You also look to that. Paragraph 2, they say judgment was passed on months.
There's no difficulty. Yes, that I've seen.
Yeah. And the judgment, the direction was made within a period of 2-3 months, not to comply. Then also see paragraph 3, that it is humbly submitted, the writ application was disposed of on 1/6/2023. The impugned judgment was sent to by the Office of the Advocate General on 1/7/2023, 1 month left, along with the opinion of the Honorable Advocate General in the context of the
appeal. The appeal period is 90 days.
Appeal period is 90 days.
Not difficult.
Sorry, writ appeal period is 30 days. 30 days. Now, after expiry of 30 days, they received, all right. Then impugned judgment was sent by the Office of the Advocate General on
after receiving 1/7, immediately on 12/7 they have.
They received the Office of the applicant on 12/7. Soon after receipt of the impugned judgment required.
Immediately on 14/7 they have.
14/7. Then they also look to the next page.
So no delay actually.
Then 14/7 to 31/7. That means if your worship will see that 14/7 to 31/7.
No. There is some decision has to be taken. This is difference. As you know, the Supreme Court has said that in one judgment it was said day-to-day explanation has to be done. In a very next judgment, the Supreme Court says that no, this theory of day-to-day is not appropriate.
But at the same time,
why not hourly basis one has to give a explanation.
At the same
Supreme Court deprecated it. There is some symmetry. If there is a symmetry and immovability in the government department is well known to everybody.
At the same time, we also can Section 3 and Section 5.
Yes.
Section 3 and Section 5. Section 3 is a limitation, is a right, vested right. Then Section 5 is an exception.
Drawing from Justice Mittal's judgment.
That you also can. That is for your lordship's. But here is a case, right from 2002, they have been continuing against the sanctioned portion of a look to that. And the Honorable Single Judge has directed to the regularization of
it was really a fault at the office of at best, one can observe in the office of the Advocate General. At least the litigant cannot be said to be at fault. They promptly take some decisions. Maybe there was 5 days delay or a 4 days delay, they ought to have taken, but those are immaterial. In this case, at least. Other cases, there is no explanation which we have related. They have not said anything. Then we can't. But this case, I think, you have some better case this time.
This time. But sir, in many cases, your lordship can look to the merit of the case. Merit, if you also look to the judgment of
now the latest judgment says that you should not look.
That is exactly.
That is the whole
case. Yes, that's correct.
That's the whole trouble.
While consider the question of limitation of the merit may not be looked into, whatever merit may be.
But there are a larger bench decision. It says merit should also be taken into account, and a meritorious or a meritorious appeal.
Yes, there are also yes. That's right. So there are other the 4 appeals, same arising out of the same common judgment. All are barred by limitations.
Right, it's very important. Right is very important.
Which?
Ramagoda case. What an ultimate analysis suffers is the public interest. That is inanimate body. Government is an inanimate body. It runs through functionaries.
In many of the judgments have said that since there is particular inordinate delay in that decision, so this is a very it's an ordeal of the things. It comes in the government. Nobody takes responsibility, and they move in their own pace.
4 other writ appeals filed against the very same judgment. Those are also brought by limitation. I think if your lordship will put up all these matters at a time.
Regularization.
Regularization.
Matter.
Yes, right from 2002 they have been conducted against the sanctioned post.
Regularization has been allowed.
Allowed.
Contempt is taken out.
Contempt is taken.
Why so averse to the regularization?
Now the judgment will also, the latest judgment will also see that. That Jago judge.
Jago.
Yes.
Jago.
Even part-time, even contractual.
Justice Nath's judgment. Justice Nath's judgment.
Yes.
Vikram Nath's judgment.
Right from paragraph 10.
But my learned senior was saying, well,
Yes, Justice Vikram Nath's judgment.
Yes.
what my learned senior was saying about 4 identical cases happened in England, all these matters they heard on a single day on merit, not happening on this.
That is what.
Now, Damocles sword, you want to.
Democratic sword.
Damocles sword, and that is Supreme Court said.
Democratic.
Keeping them on tenterhooks. You keeping them their services in tenterhooks. You put the Damocles sword on their head after so many years of their service. You just discharge them and remove them, and that is what Sripal also 2025.
Yes.
After this Jago.
One of the judgment, the Supreme Court has made a very apt observation. The sword is hanging above the head of the litigant and is moving like a pendulum. Nobody knows when it will fall and hit the bullseye. 83.2 or 82.3. I always make a confusion in between that. It's a four paragraph judgment. Swinging pendulum, we used to term it. Swinging pendulum. So same, the Damocles and the swinging of the sword is what to do, sir? I think this is the case where we can.
The service sometimes Supreme Court said, but now. The lordships.
Yes. So we'll fix the matter.
Yes.
Here, let us condone the delay.
That's right.
In this. Yes. The application under Section 5 of the Limitation Act for condonation of delay in preferring the instant appeal is at the behest of the state of Orissa, feeling aggrieved by the judgment dated 1/6/2023 passed by the signal bench in WPC number 12485/2019. Since the period of delay appeared to be inordinate, the opportunity was given to the respondent to file counter affidavit. The counter affidavit is on record, where the respondents have been categorical that the facts pleaded in the application for condonation of delay does not constitute a sufficient cause, and there is an apparent lapses and or carelessness attributable to the conduct of the officers who were in the helm of affairs. Next slide. Admittedly, there is a delay of 303 days. 3 days in preferring the instant appeal against the judgment dated 1/2023 passed by the single bench. It is averred in the instant application that the order impugned in the instant appeal, though passed on 1st June 2023, but was communicated by the Office of the Advocate General on 1/7/2023, containing an opinion of the Advocate General, obviously to prefer an appeal. Immediately after the receipt of the order, along with the communication, along with the opinion of the learned Advocate General, the legal section of the administrative department took steps to process the same. On 8/8/2023, and immediately the contact with the office of the learned Advocate General was made on 19/8/2023 for preparation of an appeal. Stop. Several rounds of discussions were held between the concerned officer and the learned Advocate General, and ultimately the draft, and ultimately certain documents were required to be collated, and the law officer was instructed to scrutinize and prepare the grounds of an appeal to be perused and vetted by the learned Advocate General, which in fact consumed considerable time, and ultimately, after the approval of the learned Advocate General, the appeal was filed, but beyond the period of limitation provided therefore. Mr. Rountree, the learned senior counsel appearing for the respondent, vehemently opposes the application on the ground that while considering an application for condonation of delay, the court should not overlook the mandate given under Section 3 of the Limitation Act. Stop. He strenuously argues that though the court in Katinov decisions have unequivocally hailed that the court must take a pragmatic view in considering an application under Section 5, but the court should not absolve his responsibility to uphold the statutory mandate and must strike a balance between Section 3 and Section 5 of the said Act. He thus submits that the application deserves to be dismissed. From the sequence of events, as narrated herein above, the first and foremost thing which the court should consider is whether the appellant, whether any negligence and or carelessness in dealing with the matter can be attributable to the conduct of the appellant. Which would disentitle the litigant to have the delay condoned. The facts as narrated above appears that the moment was communicated to the department, the steps within the reasonable time as expected from the functioning of the government department was taken. And the moment the entire matter was entrusted to the learned advocate general, unless complete advice is given and the memorandum of appeal is approved by him, the authorities cannot proceed and file the appeal. It appears that several rounds of consultations were held with the law officers of the department and by the learned advocate general, and ultimately, after collation of the several documents as the learned advocate general thought are relevant for the purpose of drafting the appeal, were collated, the appeal was drafted and ultimately vetted by the learned advocate general. So the entire exercise took a considerable period of time, which according to the petitioner has been sufficiently explained. We are not unmindful of some next paragraph. We are not unmindful of somewhat certain position of law that the length of delay is immaterial under Section 5 of the Limitation Act. But what is material is the sufficiency of the cause. Stop. The delay of shorter period may not be condoned in absence of any sufficient cause shown by the litigant, whereas the delay of longer period deserves to be allowed if the court is convinced that the circumstances so disclosed prevented the appellant to file the appeal within the period of limitation. Though the government is not a privileged litigant, yet because of any responsibility to be fixed on the officer for their carelessness or a delayed decision, there occurs a delay, and such. And therefore, the court has to take a holistic view, keeping in mind the peculiarity in the characteristics of the functioning of the government department. Stop. apart from the same, the litigant who has reposed confidence on the lawyer should not suffer for any lapses or the delay committed by the lawyer in this regard. In the instant case, next paragraph, the major portion of the delay is explained. Now, major portion of the delay is because of the various discussions and of the documents for recording the satisfaction by the learned advocate general is concerned. And therefore, it cannot be said that the appellant was absolutely negligent and or lethargic in taking prompt decisions and or action in filing them. We are further conscious that while condoning the delay, the court may strike a balance between the rights of the parties. And if there is some negligence attributable to the conduct of the litigant, which was beyond his control, the same can be compensated by imposing a suitable cost. As indicated here in our, the delay was beyond the control, though there appears to be some of the appellate, to which we feel that how much
State, see, based on. How much?
not convincing my brother on a quantum.
On the quantum.
On the quantum.
I'm not saying
Six digit.
60.
6 digit to the bar association. ଆଉ 100,000 ନାହିଁ.
The Lordship, possibly your Lordship, by sitting with my Lord Justice, back only he was equal the cost, calculating 100 rupees per day.
Justice Jaswant Singh ଥରେ ଦେଇଥିଲେ. Mr. Rudrakaranଙ୍କ case. 1 lakh.
That I do not know.
If there is this kind of a delay, not less than each.
Can a state has not filed counter there, and you have preferred appeal.
You are pro forma. Yes.
University, now you have added that
So
I
how
read
much?
them
How
as,
much? Tell us.
No loss, whatever. Accept that.
uh, 50,000. Within 4 weeks to the 50,000 within 4 weeks to the Bar Association Advocates Welfare Fund, Odisha High Court Bars.
The 4 other appeals are there. 4 other appeals are raising the same comment letter.
Because of extraordinary. Because of extraordinary.
For other matters, what are the delay?
Same.
Oh, they are not listed.
Not listed.
Then let it be listed. Give the slip.
Yes, I'll give you the slip. I'll give you the slip.
It's called the 25.
Item 25.
Only prayer now, if both cases is the same order in past.
There in one of the matter, the state filed 20 appeals. And there was a delay. That was in relation to a land acquisition. So there was a delay in that. So I condoned it. There was a delay of 1,400 something things. So I condoned it, no difficulty with this amount. And it was in all the cases the equivalent amount. And for the cause of the destitute children of the homes. So it was given to them. So that many homes, they do not have a proper purified drinking, the machines. They do not have the good toilets. They do not have this. So this money was spent for that good cause. Consider a welfare state so always takes care of the citizens of the state.
That is correct. But here it is.
Item 12.
Let us see another other matters. They are not
Matter.
Yes, sir.
Item 25.
Item 25, already the objection, but that has not come to the record. Just now, I already appeared the objection. But actually, next week.
Item 26.
This is copy not in some. 26 limitation personal copy not some.
Termination application not sir.
Not some. Therefore, serve a copy. And next week one 11/149.
Next week.
Next week.
Item 27.
Item 27.
Last order is with this. 30th of April 2025.
27.
Limited this.
27.
Fighting again, you are fighting for condonation.
Lord, as your Lordship has rightly said, I was sitting outside and watching your Lordship's word. Even if it is shorter, required to explain. But bereft of that, I have got 2 judgments to assist your Lordship. As your Lordship, both the ends, your Lordship is saying, Lord, whatever observation given by my Lords, even at the time of continuing delay, merits can be gone into. And the earlier judgment says, merits should not be gone into.
Latter judgment says should not be gone into. Earlier says can be gone into.
So kindly see those 2 judgments. I have got to assist your Lordship on that point. Kindly see those 2 judgments.
Here, my
Lord, one second, Mr. Das. Let us discuss on the question of law. My learned friend will say, Lord, this is the judgment dated 21st of March 25. This says in para 14, page 58 of my note, my Lord, kindly. Mr. Das, academically we were discussing, not on notes. Kindly see page 58. Then the Subharati judgment is, kindly see, is 8th of April 25, which says merits should not be gone into. But you've seen that these 2 judgments. So the earlier judgment says merits should not be gone into. The latter judgment said merits can be gone into. My Lord's Honorable Chief Justice.
Yes.
Probably my Lord's Honorable Chief Justice is
No, I'm just looking at the older ones.
Earlier, still earlier.
You are talking about the judgment of Justice Mittal and Justice Padiwala.
Not that authority.
That is what you are. I'm just going by earlier. The larger base.
The Lordship did not see the earlier one. Lordship see the recent one also that says merits can be gone into. Kindly see that one. I am giving along with my note.
55.
Page 58, para 14. It's a very peculiar situation now. Kindly see this.
That judgment is taken care of in this.
Sovereignty has been discussed, but not overruled because
I believe there are two judgments you can also take into consideration. 1996, volume 3 SC, page 132. And there is another judgment of 2000, volume 9 SC, page 94.
take down these two judgments. I'll just give little more one.
And take into consideration 2011, volume 4 SSC, page 363 as well.
They all these judgments say merits can be gone into.
The larger quorum judgment.
So those definitely prevail upon the sovereignty judgment matter. If taking that into consideration, Lordship passed the last order, even going into the merits, limited the scope of adjudication to 2 points. That finance department took a decision to.
It says that the time when the meritorious matters, it appears to the court on the face of the reading of the cost papers that there is some merit.
Right.
May not ultimately succeed, but there appears to be a prima facie or a tentative view that there is a merit.
Yes.
The court should condone it.
So that is why
we should condone it and let it decide on merit and throw in.
Looking at that, your Lordship passed this order. Your Lordship has already invoked your Lordship jurisdiction and passed order on 30th of April. Kindly see this order. Your Lordship has limited it to 2 scopes. Kindly see, only 2 aspects. Now they should come back to your Lordship on these specific 2 points, not any other aspect. Your Lordship has already dealt with these matters. Now instead of jumping,
is the both foreign and both police.
yes.
Can it go?
Now to further, when there are conflicting views of 2 coordinate benches of the Honorable Supreme Court, the law says that
refer to a Chief Justice
larger bench, or if the earlier judgment is not overruled.
That is the Calcutta view was there. That was in the
so grateful
Bholanath Karmakar's case.
Right.
There it says that the one which is more close to the facts.
Yes.
That should be followed.
Yes.
But no longer a good law.
No longer a good law, but recent law Supreme Court
community of Daudi was a commission decision.
But Supreme Court very recently says once the 2 coordinate benches give a conflicting view, it should be referred to the larger bench. If it is not referred to the larger bench and still that position continues, the earlier judgment giving a contrary view should be overruled in the latter judgment. Unless overruled, the latter judgment will hold the field, meaning thereby merits can be gone into. I am one with my Lord's view. Am I not clear, man?
Concept of latter and equal has gone. Previously,
I could not clarify. No, it's like this.
The notion was that there were initially under the common law principles that it is the latter judgment which would prevail.
That's right.
And then subsequently it says no, it's the earlier judgment which should prevail because the latter would be par incuriam, unnoticing.
Yes. Without considering the earlier view.
That's why. So par incuriam.
Subsilentio
is a different one. It's a par incuriam.
Par incuriam, the Lordship can say par incuriam.
Notice the same judgment on
right, right.
So that was view. Then suddenly the view came that you should not have taken a contrary view. The proper course is to refer to
the larger bench.
Then the Chief Justice to constitute a
larger. Now
and then there was a complete silence. Then what would happen if it is not done?
Yes. Then
a view evolved that both the judgments are equally applicable. Now you choose when the matter comes.
Which one will
fact
fit to
is
the
more
case?
close to which one?
Which one will fit to the case?
Which one will fit to the
But to just to
follow that. That's
just
very difficult.
just to supplement, my lord, just to supplement, the one more view is that if the earlier judgment with conflicting view is not overruled in the latter judgment, then the latter judgment will be considered, not the earlier.
And latter judgment considered the earlier one.
Then only, yes. Yes. If the latter judgment doesn't say that the earlier judgment is wrong, then the latter judgment will be considered. And in our case here, 2025, latter judgment.
I fully agree with you. But I lost when I was there on that side.
So interesting is the position.
I could not convince the division bench.
But now the view which your lordship is taking, I think my suggestion is just to support your view now, sitting that side. Sitting that side, whatever view your lordship is expressing, the ratio is that, the principle is that. If the earlier judgment is not held wrong in the latter judgment, then the principle in the latter judgment will hold the free. And the latter judgment in this case says that merits can be gone in.
No. What for? To a limited extent of condonation. If the court found that there are some meritorious matters are there, prima facie, it is a prima facie. Ultimately, the court may not accept that particular proposition, but still the condonation has to be done and the decision should be taken on merit. Now I understand the counsel is so vociferous in making an argument because he is opposing.
No, but that position that position today doesn't exist in view of my lord's last order. Last order, your lordship has already gone into the merits. Your lordship has seen the finance department's letter. Your lordship has seen the law department's letter. Both of them have decided to regularize this case because out of 9, they have regularized 8. And I am only the residual man.
That's for limited purpose, we have to hear him that why he wanted to challenge the order.
Regarding that, I have gathered instruction. So also various documents. So I'll just put it by way of an affidavit in reply to that. Will also may grant me a week's time. I'll do it.
Rejoinder.
Rejoinder, I'll have to because
unnecessarily we had so much of academic discussions.
That is why I was trying to object my learned friend, my learned senior. My learned senior said that it is only for academic purpose I am discussing, so it will be taken up some.
No, we will have a mini discussion in another podium.
As your lordship, please, madam.
Here only there is a delay of 91 days, man.
But then it has to be explained.
As he took the observations from me in the earlier judgment.
Yes.
The length is immaterial. And these are the consistent view of the Supreme Court.
Yes.
It says length is immaterial.
And your lordship see that paragraph, your lordship will
also
ask.
Nothing. Will have a glass.
Nothing.
These
case.
But this is only for one Supreme Court judgment of Sevraj Singh.
Sevraj is relied upon. 2023 judgment.
2023 judgment, and the Honorable Apex Court has taken into consideration as many as 13 judgments, previous judgments, and passed this.
Sevraj, Subbareddy, everything is relied upon in the judgments which I am citing.
And here the delay was 490 days in filing the land acquisition appeal as against the order.
Anyhow, yes, the counter affidavit is filed through an application for continuation of delay. It is fervently submitted by the senior counsel appealing for the respondent that there is a complete lack of explanation given in the application for continuation of delay, and therefore the court should not proceed to allow the same, taking shelter under the concept of lenient approach or a pragmatic view to be taken. The counsel for the state submits that they will be permitted to file a rejoinder to the state counter affidavit. The time to file rejoinder let the rejoinder be filed within a week, 2 weeks from date or 1 week?
1 week.
Week from date. List the matter accordingly. We'll have a good discussion on this.
Right, I'm so grateful.
Item number 28. Item 20.
Has been a delay of 214 days.
Is what you say.
Yes, your lordship. I am telling in paragraph 2 to 6, in date of bill, the 213 days is important to mention the opponent being fully aware of the date of retirement of the respondent and aware of the order of dated to 47/1/25 as by the Honorable Court. And see of my objection, page 3, paragraph 5. My objection. The appellant being fully aware of the date of retirement of the respondent and aware of the order dated 27/1/25 Court in content case number 731.
There is no explanation just given. In that matter, there was a wonderful way of depicting the steps which are here completely lack of.
Conscious of that.
Then how can it be done? How can it be done?
Your lordship is pretty correct. 100%. Only thing I was pointing out on the last occasion, it's like my friend, that is deliberate. We have
But what more can be done? Because it is neither stated bona fide nor stated mala fide, then what we will gather. Nothing has been given.
I am conscious of that.
So what, in the absence of any explanation, what can be done? Would you like to file rejoinder?
1 week, your lordship, give me within that period. If I will
rejoinder within a week.
Item 29.
Item 29, my lord, there is a nothing that IA 2094 of 2025 is sluggish for dispensing with filing of certified copy. I undertake to file it within a period of 2-3 days.
First, may I think may not be required. Because I am the opposite part number 2. I also challenge that particular judgment in WA number 2955 of 2023. I have relied upon the certified copy of this.
So this party number 2 is
One eviction.
the writ petitioner or not a writ petitioner?
No, I was the opposite part number 2.
In the writ petition. So you have also filed.
Yes.
And they were the opposite party number 1. So they have also filed.
Yes.
So
one judgment, that judgment, certified copy of the judgment, I relied upon.
So both the enemies becomes a friend.
No, it is we are all studying the same footing.
My learned friend.
So both have suffered an order.
Yes.
They have joined together.
Yes.
Direction was given to opposite party number 2.
Where is the notice upon the opposite party number 1? Notice is issued.
The issue matters.
The notice has been issued.
No.
Then issued notice, not the copy of the application.
So for my appeal is concerned,
it will be listed, don't worry.
In our case, notice has not been issued.
There also the delay.
No.
There is no delay.
No delay.
In this case, you'll have to give a notice. It will tag both the appeals.
Yes.
And what they will decide. Don't
Only
worry.
thing I wanted to point out, my lord, since the single order has been challenged by both of us, and there,
if the dismissal in one will really affect something else, we know. Don't worry, we are conscious. But at least he started to a notice.
Yeah.
May I only point out one thing, my lord, the content is staring at us at Mr. 9. Content petition.
The list is matter tomorrow. Give the number. In his matter, it is the. Your matter is already there.
It is there.
Oh,
connected.
Both the cases have been connected.
Your matter is which one?
Or second one. 2955.
What is the matter about?
Matters.
Madam, if your lordship permits me, although it is his case, if your lordship permits me, In a writ application, opposite party number 1 was the state, 1B was the opposite party number 2. There was a direction to the opposite party number 2. But while passing the direction, the impugned order which was passed with opposite party number 1 was passed. Since a direction was given to the opposite party number 2, they approached your lordship in this writ application. 2955. We didn't file a writ application. We approached subsequently when the question arose that our order was passed. We didn't challenge. That is how we have approached your lordship at a belated stage. In the other writ appeal filed by my learned friend, there no limitation question was there. They have filed it at the right time. That what I found from this record. They have filed it at the right time.
Direction that
My
is
lords,
passed.
may I submit my lords now in nutshell, my lords. The petitioners were the parent of the children, those who are reading in a school manners, LKG, UKG school manners, which is opened in the Palmi premises.
You know?
Valmi, Mr. Appellant's premises.
Water and Land Management Institution.
Water and Land Management Research Institution. It's a research institution incorporated under the Society Registration Act, under the administrative control of the Water Resource Department. There, the management decided that we read that that the school should not operate. These people, these three petitioners, they must read petitioners. They challenged the same with the read petition on the ground that the school should continue to run, and the teachers, those who are teaching there, they should continue. They should continue. So then, High Court.
Who are these three persons? They are the parents.
They are the parent of the children. As on that date, the day the case was disposed of, their children were not ready. And these matter, if it would be taken up in a different context, it would be a PIL. But anyway, on single just took up the matter and directed now. What's very important is that these two teachers, those who are continuing there, they filed separate petition, lost there. Now the Honorable Court held that they should be entitled to wages because on the ground that the school is operating throughout, and they should be entitled to get the benefits. The benefits of the areas. And there is a direction to the government to open the school again under the guidance of the School and Mass Education Department.
But the school is still running.
No, my lord. No, long, this is not running. In spite of the order of the
where the students have gone.
The student, LKG, UKG student minors. Which are all LKG, UKG students. Thereafter, a number of schools are around minors. This is minors in between Cuttack and Bhubaneswar main road. The people, the students, those who, the students of the staff, those who are reading there, they are now either in Cuttack, they are or reading in Bhubaneswar. Adjoining also, there are a number of schools. So, the management.
Where is the ultimate this?
Page, my lords. Now, kind of comes to page 55. To my copy. Well, sir, WA number 2955, page 55, paragraph 30.
Of this order.
Yes, judgment.
Page 68 is the last one.
Yes, 68 is last. Page 50, the operating portion minutes. It's page 67 and 68 minutes. It starts from paragraph 66 minutes.
We are for the purpose of an interim order, we are looking at.
Yes, ma'am.
Then what is been ultimately directed?
Minutes. In view of the aforesaid analysis of the paragraph 54 minutes. Page start from page 56.
Just give us 30 seconds. I'm a very fast reader, don't worry. But there was an interim order to close the school.
No, there was an interim order
that I hold that it was functioning, and you say it is not functioning.
Not functioning. That is the thing was the interim order was operation of Annex 3.
So interim order was to what extent it was passed? What was the nature
modern
of the
my
interim?
my non senior my honorable single just quoted it. That is at page. Interim stay of Annex 3.
What is Annexure 3?
Well, kind of not to Annex 3. Annex in that manner, we directed not to give admission to the students.
Now there is no student.
Yes, no student.
Have you stated in your petition?
Yes.
Where?
Also in the writ appeal manner.
Yes. Where you have stated that there is no admission, there is no student, there is no.
Yes.
The ward is studying in the school. The school is closed. Where you have stated?
Yes, sir. Clause number please
In
17.
the interim application, you have not stated, sir.
No, that I stated.
No. I have read your interim. There is nothing.
Interim petition, no, grounds. I'm just down.
No, sir. When you are asking for an interim order, I have to. We have to consider it on the basis of the award.
Yes.
You have not said anything.
But so far, I is concerned.
Yes, you ought to have said.
I am
why the interim order is required.
But I am minors.
No, I have read. Nothing has been said.
Just I will be for 1 minute.
And ground is not a part of the affidavit, I believe.
Yes.
Nothing you have said in the IM. File an additional affidavit, otherwise we can't.
Well, so I will file an additional affidavit, my lords, by tomorrow, my lords.
Within 2 days. Appear after. Yes, 30th.
Item 30 is for original, my lord.
Yes, sir.
Item
30 put for
30 may be permitted to withdraw liberty to file a better petition. May I submit my
Is not a better petition.
Lord, the jurisdiction, the writ petition criminal has been filed, it has to be revision.
The government liberty to file.
And Lord, one more prayer, Lord, there is a certified copy along with a memo.
Yes,
That may
return
kindly
about replacement with the photocopy.
Yes.
Grateful.
Yes, submit my lords. And it is very cool one minute. Part of my lords,
I read, this is not expressly.
Yes,
You have said that the closer will suffer something.
but 9th my lords are not fixed of the.
Please come by tomorrow, you said.
Yes.
2 days time we have given and the matter is listed after 2 days. Immediately.
Then my lords are job. Then a problem.
Yes, on the
Item 31.
who is appearing?
Item 31. The first item, my lord, I am appealing for the respondent. The appeal by statement.
Appeal by state. Here the matter is for the Honorable Supreme Court in SLPC number 16949 of 2023 is any pending.
My lord, state preferred appeal, my lord, because division bench.
So now why this matter is listed if it is pending?
My lord, state preferred, my lord. The earlier batch of application preferred by state, my lord, dismissed by this coordinate bench by your lordship, my lord.
And submission is, my lord, let this appeal may lie over. Disposal of that SLPC
So
number.
the point involved in
Yes.
that matter before the Supreme Court is same.
Same, my lord.
And can you give me the number?
Number is not SLPC number
It is
16949.
uniformly submitted by the councils appearing for both the parties. That the point involved in the instant writ appeal was identical and similar in another writ appeal, which was disposed of by this court. And the matter is pending before the appeal court.
That copy of that rate.
Especially the petition, the
SLPC appeal number 16949 of 2023.
SLP number.
SLP civil number, yes, ma'am.
There are two numbers, civil appeal or SLP?
No, SLP.
The special, the SMC within bracket C number 16949 of 2023 is pending before the apex court. Stop. Since the point involved in the incident rate appeal is subject is let this matter be adjourned Senada. Next, liberty is granted to the respective the councils to mention after the matter is disposed of by the
Only item sub item 1 man.
Yes, there are.
The other matters are different.
Two sub items are there in
they are not.
They are not identical.
So you are appearing for all.
No, my lord, in item 1. Sub item 1.
Right. So keep it, detach it.
Yes, sir.
Yes, sir.
And this matter on the other day.
Yes, sir.
Yes.
32.
Item 32, my lord.
But it's still matter. Kindly see the last order. That is as per the Jago, that this is the and the opposite party, my lord. He was regularized in 2015. They have revoked it. Then, my lord.
Oh, if they have
Oh,
not
my
given
lord,
an
yes.
explanation, then we can.
No,
They
this
know it.
delay is content and everything. Wait for hearing.
Let us see. Yes, sorry, we have.
Well,
lots of questions.
Item number 16 and 14.
Huh?
Item 13 and 14. Short clipping of liquor. Face matter.
Short listing.
Short clipping.
Going for the other side.
State.
Oh,
Item 38, a batch of cases. In all the cases, the counter affidavit is required to be filed. Because the policy
short
of the
listing, he says.
that is for
Press matter. Item 13.
press matters.
Keep it tomorrow. I will just. Keep it tomorrow. These matters, keep it tomorrow.
This is too much.